All right, we are almost live.
Thank you. I see that now displayed on my screen. And Ms. Pfeiffer, I see you on the screen, and I'm assuming you're connecting via audio the same way you did yesterday with a speakerphone.
That's correct, and everybody is present and ready to go.
Okay. And I didn't see that Mr. Urbis was logged in, but is he there, or we need to wait for him?
He's here. He's logging in right now. It's just we're a little slow. We can start because he can see us on the other projection too.
On the large monitor. All right. And Ms. Schultz, are you ready?
I am ready.
And Mr. Samano, are you ready?
Yes, sir.
And Chief, are you ready?
Good morning.
Good morning. All right, then Ms. Schultz, let's go on the record. We're resuming the second day of the hearing in this matter of Samano and the city of San Antonio with American Arbitration Association number 01-19-0001-3036. And I believe we adjourned yesterday with being ready to draw the chief. So, Mr. Cervantes, are you ready to begin?
Yes.
Then please proceed.
Chief, I'm happy to look at COSA 0002. It should be in tab 1 of the city exhibits.
I'm sorry, can we please stop for a moment? There's some noises coming from somewhere. Now it stopped. I'm not sure. Somebody's moving around and making noises and I can't hear.
So have we fixed the audio problem
I
for you?
believe so. I believe so. Thank you. I'm so sorry.
That's all right. Whenever you have a problem with audio, just let us know. And when anybody else has problem with audio or video, please let us know. All right. So I think, Mr. Cervantes, you were asking the witness to look at appellant exhibit, and I believe it was the second page.
No, it's the city exhibit.
Oh, the city exhibit. Thank you.
COSA 0002. It's under tab 1.
Thank you, sir.
And Chief, you understand that I don't know.
I heard the noise again.
Yeah. I don't know why there's feedback. I'm going to give it a try. Can you tell us, Chief?
Mr. Fuentes, I believe it's you.
Well,
Why
why don't we go off the record? And Mr. Cervantes, why don't you just turn off your audio and we'll see if that's still there, and we'll go down that route. So is it still there, or is it disappearing?
hard to tell.
Well,
It's still happening.
All right, then let's do it one by one. Mr. Samano, if I can ask you to turn off your audio.
Yes, sir.
All right, did that clear it? No, I'm still hearing a bit of a static. Or did it disappear then?
I don't hear it now.
All right. Let's try to turn back on Mrs. Fuentes and see if it stays away. And that may mean it was Mr. Samano's. And Mr.
Okay,
Fuentes, why don't you start again?
all right. Chief,
No, it came back.
Turn ours off.
It might be the cities. We're gonna
Turn ours off
disconnect
so
it
he
and
answers
turn
the
it back
question.
on.
All right.
If we, oh. Maybe that's. All right. Oh, we're back on. Can you hear the feedback now?
No. But let's see what happens when Mr. Fuentes tries to speak and see if it's gone away for sure. And Mr. Fuentes, why don't you just say a few words and we'll test your audio.
testing 1, 2, 3, testing 1, 2, 3.
And I don't hear anything right now in feedback. Ms. Schultz, are you hearing anything?
I am not.
All right. And Mr. Samano, we'll leave your audio off for the moment. And if you need to speak at some point, usually if you just hit your space bar, that will turn your microphone back on. All right, sir? All right, thank you. So, Mr. Fuentes, why don't you begin again? And the court reporter, we can go back on the record, Ms. Schultz.
Chief, can you tell us in reading COSA 0002 in your narrative, what part of the narrative violated each of the rules that you cited? So in other words, what I want you to do is read each sentence one by one on or about January 31st, 2019. After you read that sentence, tell us whether you think it violated 2.02, 3.01, 4.07, or 4.09. Okay? You understand what I'm asking you to do?
Not necessarily.
All right. So, well, then let me do it for you. On or about January 31, 2019, at approximately 2:10 a.m., while off duty, firefighter Samano was observed by DPS state trooper driving erratically, failing to drive in a single lane and failing to signal change of lane. What rule did that violate? You cite 2.02, 3.01, 4.07, and 4.09. What rule did that violate?
For clarification, he's asking, Chief, he's asking which rules and
Don't
regs.
explain to the witness my question. Don't explain to the witness my question. You're coaching the witness. You cannot coach the witness.
Well,
Nobody was coaching. I was trying to assist because there's clearly some confusion, Mr. Fuentes, but I'll be happy to let you proceed.
and Chief, if you don't understand the question, just tell us and we'll have Mr. Fuentes explain or rephrase.
Yes, sir.
Okay. The sentence that I read, the first sentence that says on or about January 31st, 2019, and it continues to signal to change a lane, did that violate rule 2.02?
Yes, sir.
Did it violate 3.01?
No, sir.
Did it violate 4.07?
No, sir.
Did it violate 4.09?
No, sir.
Okay, you said it violated 2.02. Explain how it violated 2.02.
It talks about abiding the laws.
Mr. Hartzell, I'm going to object to this line of questioning if I can get a running objection. breaking it down piece by piece with only citing certain part of the facts and not all of the facts misrepresents the evidence, because he's already testified, he's taken everything in totality of the circumstances.
Well, I'll overrule the objection. I'll give you a running objection, and I'll take the witness's testimony as his understanding of the rules and the narrative that's in City Exhibit 1.
Okay. Explain how it violated 2.02.
As far as the lane change,
Yes.
as far as the illegal lane change, or failing to drive in a single lane while failing to signal change of lane.
All right. You've never issued any suspension to anyone for a violation of a traffic code, correct?
No, sir.
You agree with me?
No, sir.
Okay, so a simple Class C misdemeanor alone, you've suspended people before?
No, sir.
So you have not suspended people for traffic violation, correct?
No, sir.
All right. You haven't terminated anyone for traffic violation alone, have you?
No, sir.
So you can't name a person you fired for violating a traffic violation alone, can you?
No, sir.
All right. The next sentence, firefighter Samano was pulled over by the trooper. What did that violate 2.02?
No, sir.
Did it violate 3.01?
No, sir.
Did it violate 4.07?
No, sir.
Did it violate 4.09?
No, sir.
All right. The next sentence, the trooper noted that firefighter Samano's eyes were glossy and he detected a strong smell of intoxicants. Did that violate any rule?
No, sir.
All right. The trooper attempted to conduct a field sobriety test, but was unable to complete the test based upon Samano's failure to follow directions. Did that violate any rule?
No, sir.
All right. Firefighter Samano was arrested for driving while intoxicated, handcuffed, and placed in the trooper's vehicle. What rule, if any, did that violate that you cited in your suspension of Mr. Samano?
Two point 2.02, 3.01, 4.07, and 4.09.
All right. So not every instance of violating 4.07 results in termination of an employee. Would you agree?
No, sir.
You don't agree?
I'm sorry, you said what? Ask again, please.
All right. Just because someone violates 4.07 doesn't mean they're going to be fired. Would you agree?
Yes, sir. I agree.
Okay. And in fact, newspapers can portray members of the fire department in a false or misleading light. And you've seen that personally, correct?
Yes, sir.
And not all the time is a newspaper fair to firefighters, including you, correct?
Talking about
Objection.
this.
I don't
What the
understand
fuck
what
out
a
of here?
newspaper has to do. A newspaper article hasn't even been mentioned. We're talking about what's in COSA 002.
Well, 4.07 deals with negative public image, and newspapers certainly covers that.
I'll overrule the objection and I'll give you some room, Mr. Cervantes. And Ms. Pfeiffer, I'll give you a running objection to this line of questioning.
Can you read back the question?
4.7 deals with anything public. in the newspaper certainly covers that. Well, 4.7 deals with anything public. Public image of newspaper certainly covers that.
Okay, there was a question before that I asked.
Okay. And not all the time is newspapers fair to firefighters, including you, correct?
Absolutely. You know very well, Mr. Cifuentes.
All right. Now, let me read the next. At that point, firefighter Samano became belligerent, using derogatory language, and told the trooper he should pray he never needed firefighter Samano's services because firefighter Samano would not help him or his family. Can you tell us which of the rules that you cited are violated by that sentence?
Yes, sir. 3.1, 4.07.
So that violates 3.01 and 4.07?
Yes, sir.
Okay. And then it goes on to say firefighter Samano became violent, kicking the inside of his patrol unit, causing damage to the air vent, striking the front windshield, and kicking the inside camera. Which rules does that violate?
.202, 3.1, 4.07.
All right. Then it says the blood draw revealed firefighter Samano blood alcohol level to be 0.12. What does that violate?
Uh, 4.09.
All right. And then the last sentence, he was charged with DWI first offense and criminal mischief 100 to 750. What does that violate?
202, 301, 4.07, 4.09.
All right. I noticed that you make a distinction of DWI first offense. Why did you make a notation of first offense?
Well, you know, whenever we have any of these now, it's a first offense after the last memo. We're not getting second offenders in here, or they're terminated. So this was Mr. Samano's first offense.
All right. So if someone has been arrested more than once for DWI, does it depend upon what the district attorney does in terms of charging a second offense, or do you look at the history of someone being involved in DWIs?
Mr. Cifuentes, you broke up on part of that question. I'm sorry.
Okay. When you decide to charge someone with either a first or second DWI, do you look at what the DA did, or do you look at the history of that particular firefighter?
Well, we look at the history of that firefighter and, again, what the person's charged with.
Okay. So if the DA does not charge somebody with the second DWI, but the person has a history of 3 or more DWIs, are they covered by the first DWI or second DWI? What do you do when the DA misses the ball?
I'm not understanding your question, sir.
Okay. Are you aware that some of your firefighters have been arrested 2 or more times for DWI?
Absolutely. We went over a long list of them yesterday, several of them up to 3 times. So absolutely, but those fell into different time frames. Some of those members that we talked about yesterday are no longer on this job because of those reasons.
Okay. So when a person has a 3rd DWI under the new policy, is he automatically fired, or does it depend upon whether the DA charges him with the 2nd or 3rd DWI?
What time frame are we talking about?
As I said, when the 3rd DWI happens under the new policy, what happens?
They'd be terminated.
Okay. So it doesn't matter whether, and when I talk about the new policy, I'm talking about the policy that was in effect for David Samano.
Yes, sir.
Is your answer still the same?
Yes, sir.
And so they would be terminated when the DA chooses to enhance the current DWI arrest or not. You look at their history, correct?
Yes, sir.
All right. Now, did you talk to Trooper De La Garza about this arrest?
No, sir.
Did you talk to anyone at DPS about this arrest?
No, sir.
Did you ask for any photographs from DPS of the alleged damage?
No, sir.
And you were aware that David Samano did go to DPS substation after his arrest and attempted to apologize directly to the trooper. You were aware of that, correct?
No, sir.
He didn't tell you that during his meeting?
Not that I remember.
Okay. Now, you're aware that DPS never provided proof of damage to either the DA or to Mr. Samano. Are you aware of that?
Not to my knowledge.
Okay. So let me ask you in the converse, did you ever see any proof of the damage other than the report that Trooper De La Garza wrote?
No, sir. All I saw was the reports.
Okay, so you didn't see a cost estimate for the amount of repairs, did you?
No, sir.
Did you bother to ask the DA's office why they rejected the criminal mischief case?
No, sir.
Did you ask any of your EMTs that responded whether they spoke to the trooper about any alleged damage?
That would not be in their realm of responsibilities. They were responding on a medical incident, so they're not going to talk to a trooper about why a person was arrested or what damage. So that's not going to happen.
That's not the question that I asked. Can you repeat the question and please answer it?
Now, why don't you repeat it for me, please?
I am speaking to the court reporter, sir.
Yes. Did you ask any of the EMTs that responded whether they spoke to the trooper about the alleged damage?
It's either a yes
No.
or no. All
No.
right. Did you watch any body camera video of this incident?
There was none available.
All right. Did you ask for it?
No, sir.
All right. So you don't know whether it was available or not, do you?
I've only had video on 2 different occasions on any DWI I've had, so we didn't have video available.
Okay. You don't know whether it was available, do you?
No, sir.
You never bothered to ask if it was available, did you?
No, sir.
All right. So would the punishment have been the same if there was no alleged criminal mischief?
I'm just going to renew my objection that he's piecemealing this together and he's not looking at it in the totality. And with optional completeness, we have the ability to bring in everything that he did that was listed within the final indefinite.
And I'll continue to give you that running objection.
If the
And
court
Chief,
reporter,
if you need the question repeated, just
Yes,
tell
sir,
me.
please.
court reporter could read that back.
So would the punishment have been the same if there was no alleged criminal mischief?
Yes, it could have been the same because, again, there was a belligerent factor that we had to look at.
All right. Now, it's my understanding from your prior testimony that before you issue discipline in any case, you consult with your team to get input on the punishment to assess. Is that correct?
Yes, sir.
All right. And that part of the team would include the city attorney, correct?
Correct.
All right. and you would rely upon the city, don't tell me what they said, but you would rely upon the city for interpretation of law, correct?
I'm going to object. He shouldn't be allowed to ask anything related to what was discussed with an attorney or what the meeting, any portion of that meeting would be attorney-client privilege.
I'm not asking for the substance. I'm just asking if there's an issue of law, he would consult with the city attorney. It's just a yes or no. It doesn't disclose the substance.
But you're
Well,
asking
but
for
it's- I think you're right at the edge and perhaps a step over when you ask him about advice about the law, because that would indicate what the topic of the conversation was. I think you can rephrase without putting in that notion about what was the topic that he discussed, that he happened to have relied on their advice, if that makes sense.
All right. So if you need to know whether something's a Class A or Class B misdemeanor, you would seek assistance, correct?
Yes, sir.
All right. And you do understand that in Texas, the range of punishment, the least offensive offense is a Class C misdemeanor, which is a ticket. The next one's a Class B misdemeanor. The next one is a Class A misdemeanor. And you can start getting into serious offenses, which include felonies, correct?
Yes, sir.
All right. And the least serious felony is a state jail. Then it's third degree, second degree, and then first degree, and then capital murder, right?
I'm sorry, I'm going to object again to relevance, but also the chief, unless we've established something that I missed, is not an expert in the legal field or in criminal proceedings.
All right.
Well, I'll take any of his answers to those questions as to his understanding, not a legal opinion. And Mr. Cervantes, I'll give you some room, but you do seem to be going far afield when you start going up to capital murder questions.
All right, so you agree as a general proposition, the more egregious an offense is under the penal code, the more seriously you take it in terms of punishment, correct?
Yes.
All right. So you consider a Class A misdemeanor more serious than a Class B misdemeanor, would you agree?
I'm not sure how to answer that because there are other components to it potentially, so I'm not sure.
Okay. All right. Now, it's my understanding, can you explain what you mean by other components?
Are you talking about one of my firefighters in particular, or are you just talking in general about Class A's and B's?
I'm asking for clarification based upon your language in the last answer. You said it depends upon the components, so I want you to explain what you meant when you said that.
Sir, I don't know.
You don't know?
No.
Okay. So when you said it depends upon the components, you didn't know what you were saying?
Sir, I'm not an attorney.
Okay. All right. Now, it's my understanding that I'm not sure if I understood whether it was belligerency or retaliation that was key in Samano's decision. Can you explain which was key?
Retaliation?
Did I misunderstand? There was no element of retaliation? You didn't consider anything he said retaliatory?
Retaliatory? I'm not understanding your line of question, sir. Retaliatory toward who?
Okay, so it's my understanding that you indicated that the reason for your decision to terminate Samano on this DWI was his belligerency or retaliation. I'm not sure. Can you explain?
I don't ever remember saying the word retaliation.
Okay, so that was not a consideration for you?
I don't understand retaliation. I mean, I understand the belligerency piece, but I'm not understanding where retaliation came in.
So just to be clear, you didn't consider his actions retaliatory when you decided to terminate him, correct?
Are you talking about retaliatory toward the officer?
Correct.
Yeah, it could be retaliatory toward the officer, sure.
But you didn't allege that as retaliation, did you?
I allege that Mr. Samano was belligerent, that Mr. Samano caused damage to the vehicle, that Mr. Samano threatened to not treat the officer if he was injured. Mr. Samano lied and said that he knew the district attorney.
All right. You did not accuse him of threatening the officer, did you?
No.
All right. Now, I want you to go to Samano 0137, and it's going to be on Daniel Drury.
Yes, sir.
All right. And you gave him a notice of indefinite suspension without pay, and then you thereafter reached a settlement agreement with him, correct?
Wait a minute. Did he say 3-7?
0137.
Okay. Hold on 1 second, sir. Okay. Go ahead.
All right. Initially, you gave him an indefinite suspension, correct?
Yes, sir.
And then you reduced it to a 30-day suspension in a settlement agreement, correct?
That's correct.
All right. And when you initially suspended him, you noted that he was arrested for retaliation, correct?
Where's the retaliation on?
On Samano 0138, in the middle of the page, it says on or about December 28th, 2019, while off duty, firefighter Drury was arrested for retaliation. You wrote that, correct?
Yes.
And you understood that when he was arrested for retaliation, that was a felony offense, correct?
No.
You did not understand that it was a felony offense?
No, sir.
Are you disputing that it's a felony offense?
No, I'm not.
Okay. And part of the factual basis for the retaliation is that there was a period when firefighter Drury was detained, and after he was detained, at the bottom of page 0138, and I quote from your suspension, that Drury stated that if the officer did not have his badge and gun, firefighter Drury would kick his ass, and stated to the officer, "Better hope I don't see you on the streets," which resulted in firefighter Drury's arrest. You would agree that's belligerent conduct, correct?
Absolutely.
And you agree that's a threat, correct?
Absolutely.
And you agree that firefighter Drury was arrested for making that statement, correct?
Absolutely.
And though that statement didn't happen in a vacuum, it happened after police were attempting to get information from firefighter Drury, correct?
Yes, sir.
And the reason they were attempting to get information from him was that he was a witness to a hit and run accident, correct?
Yes, sir.
And it wasn't just any run of the mill hit and run accident, it was the hit and run accident that happened near his home that firefighter Monica Trevino was involved in, correct?
Yes, sir.
And not only was he a witness, but he fled the scene before the police arrived, correct?
Yes, sir.
And when the police arrived, he was detained because he was wearing clothing that matched the description of someone running from the scene that other witnesses described, correct?
Yes, sir.
And so when a Bear County sheriff showed up, he detained him, Drury, because he matched that description, correct?
That's correct.
And when he was detained, firefighter Drury started cursing at the officer, correct?
Yes, sir.
And by cursing at the officer, that was belligerent conduct, correct?
Yes, sir.
And not only did he curse, but as a witness, he was refusing to answer questions, correct?
Absolutely.
And he was a witness to an offense. And as a witness to an offense, in the course of an investigation, the police are entitled to ask for his identification, correct?
Yes, sir.
And so when the police are entitled to ask for his identification, Drury failed and refused to provide his identification, correct?
Yes, sir.
And it wasn't until a Lieutenant Veda showed up and spoke to Drury did firefighter Drury respond, correct?
So I think he did that over the phone. I'm not sure if any of our personnel showed up.
All right. But he still refused to cooperate, correct?
Yes, sir.
And you cite in the suspension there that he was insubordinate. So he had been ordered by one of your supervisors for him to cooperate, and he still refused to cooperate, correct?
Yes, sir.
All right. And despite all that, having committed the crime of retaliation, been belligerent, refusing to provide information at a hit and run that happened at his house involving a fellow firefighter, he only got a 30-day suspension, correct?
Yes, sir.
So being belligerent with police doesn't necessarily result in termination, correct?
Yes, sir. We discussed that yesterday, but if he would have been driving behind a wheel, he would have been terminated.
All right. So you would agree that there have been other other firefighters under your new policy who've only been arrested for DWI and that alone who have gotten 60-day suspensions, correct?
Yes, sir.
And when there have been circumstances surrounding the arrest that suggest more severe punishment, you've increased it up to 75 days, correct?
Yes, sir.
You've increased it up to 90 days, correct?
Yes, sir.
So if normally it's 60 days, and in this case, we see Drury getting 30 days, 60 plus 30 equals 90 would be consistent with what you've done in other cases, correct?
Objection. He's piecemealing these disciplines together under completely different policies, and he's misrepresenting the evidence and calls for speculation.
Overruled. I'll give Mr. Saventus some room to make his argument. And Chief, if you need to have the question repeated since we've had this discussion about the objection? You can have it repeated.
Yes, please repeat.
It can be read back, please.
So if normally it's 60 days, and in this case, we see Drury getting 30 days, 60 plus 30 equals 90 would be consistent with what we have done in, you have done in other cases, right?
The only consistency that you will see, you mentioned yesterday Lieutenant Casals, Lieutenant Parsons. They were also arrested for their behavior. And again, whether it was physical altercation with an officer or whether it was demeaning behavior, the way they talked, they would have been terminated if they would have been behind the wheel. So we have been consistent.
All right, so you're familiar with your December 2014 policy, correct?
Yes, sir.
And would you agree that in your December 2014 policy, you don't define what surrounding circumstances are? Would you agree?
That's correct.
And when you revised it a few years later, you still did not define what surrounding circumstances are, correct?
That's correct.
All right, so my understanding that you said your 2014 policy was sent out by email, and correct me if I'm wrong, but I think you used a phrase like it was pushed out by supervisors by discussion with the troops or something like that.
Yes, sir.
Can you correct me if I'm wrong? Can you tell me exactly how it was pushed out? I don't want to misstate your testimony.
Okay. It was pushed out 20 to all the members, and then it was pushed out through the chain of command to basically go out and have those discussions with the troops.
Okay. Do you have a record of when your chain of command discussed it with the troops?
Not offhand, no, sir.
Do you know what duration the discussion happened?
No, sir.
Would you agree that in 2014 that Mr. Samano was not a member of your department?
That's correct.
And not until some years later was he hired by the department, correct?
Yes, sir.
And would you agree that you have no acknowledgement or signature sheet that David Samano received your December 2014 letter to the troops?
No, sir.
You don't agree, or you? Let me ask it this way: can you produce a signature sheet signed by David Samano that he received your December 2014 letter?
No, sir, I can't.
Okay. All right. Was this new memorandum, was it required to be signed for or not?
No, sir.
Okay, so let me see if I understand correctly. The department has rules and regulations that are in the book at tab 13 that are in front of you, correct?
Yes, sir.
And would you agree with me? These are the rules and regulations of the department, correct?
I'm sorry?
These are the rules and regulations of the department, correct?
Yes, sir.
And do I understand your testimony in previous cases that when you first came on in, was it 2009? 2007, I apologize. In 2007, you have not amended these rules and regulations, correct?
No, sir.
You agree with me?
I agree with you.
Okay. So, your memo that you wrote in 2014 was not a change in rules and regulations, was it?
No, sir.
So if I misunderstood your testimony yesterday, you're not suggesting that your 2014 memo was a change in regulations that people would be required to know as they change in regulations. You'd agree with me?
Yes, sir.
All right. Now, when you draft your suspensions, do you rely upon the police reports to decide what to accuse someone of in the narratives?
We rely on any information that we may have available to us.
Okay. And that would include police reports?
Yes, sir.
Did you get a copy of the police report of Darla Parsons
Yes, sir. And a video.
and the video?
Yes, sir.
Okay. And would you agree that in the police report of Darla Parsons, that she's listed as O1 and she advised one of the police officers on scene, according to the report, that O1 better not see Officer Harris at her station, and that if O1 sees Officer Harris, she will beat her ass. That was in the police report, correct?
Yes, sir, it was.
And it says O1 was advised not to make any threats. And as O1 and V1 were walking from the location, O1 say, "Stay the fuck out of our station." And then said to the victim in the case, "I'm going to fuck that bitch up." She made that statement, correct?
Absolutely. Very disappointing on her part. But again, she was not a DWI. She was not driving.
Okay. And do you agree with the proposition that people of higher rank should be held to a higher standard?
Absolutely.
And she was a lieutenant, correct?
Yes, sir.
And so even though as a lieutenant she should be held to a higher standard, and given that she made the threat to an officer, she only got a 30-day suspension out of that, correct?
That's correct, as with Lieutenant Casals, to my knowledge.
All right. And not only did she make the threat, but she got a criminal trespass warning from the Aztec Theater, correct?
Yes, sir.
And to your knowledge, that criminal trespass warning has not been lifted, has it?
I wouldn't know.
All right, and explain to the arbitrator what your understanding of a criminal trespass warning is.
Well, you asked me, was it still in effect?
I'm asking you, what is your understanding of a criminal trespass warning?
As far as a warning, probably to stay away from a location.
And if you don't heed that warning, what happens?
You could be arrested.
For? Arrested for what?
Trespassing?
Okay. Are you saying that as an answer or a question?
Would you ask the question again, clerk?
It's a court reporter, but
Court reporter?
And if you don't heed that warning, what happens? I'm sorry, which question? Arrested for what? Trespassing? Question, okay, are you saying that as an answer or question? Which question are you wanting me to ask?
okay. So when you said criminal trespass, were you saying that you know that's what was going to be the consequence, or were you asking me a question? And
That would be that she would be arrested. That's the consequence.
now, not only did she make threats, but she was seen kicking doors, correct?
I don't know if I saw her kicking any doors.
Okay, but that's in the police reports, isn't it?
Okay, well, it could be, but it's been a while.
All right. And the police report says before the officers allowed 01 started kicking the doors of the venue, correct?
Yes, sir.
All right. And that was in the reports, and you were aware of that, correct?
I had to refresh. Yes, sir.
All right. So would you agree that that's substantially similar to what Trooper De La Garza accused Samano of doing, of kicking his vehicle? And here we have a lieutenant kicking the doors of the venue. That's similar.
It's still not similar because they weren't involved in a vehicle. Lieutenant
Okay.
Parsons was not driving a vehicle.
All right.
That's the difference.
Okay. And let me ask you this. As far as you know, Darla Parsons never went to Officer Harris to apologize. Would you agree?
I have no idea.
Okay. So you gave the 30-day not knowing whether or not she had apologized or attempted to apologize?
You know what? When I'm weighing that, I don't know whether someone apologizes or not unless they say so. But at the time, I had no idea, and I still don't know whether they've had interaction whatsoever.
Okay, but you did have a meeting with her, correct?
Yes, sir.
And that would have been an opportunity for you to ask whether she had apologized for her conduct, correct?
You know, my meeting with her basically was to admonish her behavior. I was completely disappointed in her. So her apology at that time, I didn't talk about that. I talked about the disappointment of her actions. Oh, Big Red.
My question was very simple. You could have used that as an opportunity to ask whether she apologized, correct? Yes or no?
Yes, sir, I could have.
All right. And would you agree when you give second chances? My understanding is you're big on second chances, correct?
Absolutely.
And would you agree that part of giving people second chances is remorse?
Yeah, absolutely.
All right. Now, my understanding that you say that you often learn about your firefighters and their DWIs or their arrests by phone calls from the sheriff or from Chief of Police McManus, correct?
Yes, sir.
All right. And would you agree that after one of your firefighters, Boldway, struck 2 patrol cars, that you heard from Chief McManus about that, correct?
I can't remember. That's so long ago, I can't remember how I was notified.
At this time, since we're moving on to another discipline, can we go ahead and just take a 5-10 minute break so we can stretch our legs? And that's about an hour now.
Mr. Fuentes, are you at a stopping point for a break?
I'm okay with the break.
All right. Is 10 minutes enough, Ms. Pfeiffer, or do you need more?
Oh, 10 would be fine. Thank you.
All right, let's go off the record and take a 10-minute break. Coming back at, say, 10 after 10. And Ms. Schultz, did you get those exhibit lists that you needed?
I got the one from the city. I don't believe Mr. Fuentes' office has sent us an exhibit list.
I believe we sent an index.
Is
And,
it, okay, if I apologize if the index is with the exhibits. I didn't see it, but I didn't look close enough, to be honest with you.
well, if we haven't sent an index, I'll have Naomi send an index again.
Okay, I appreciate it. Just helps when I go to put it on the exhibit list. Let me resume, okay.
Well, since I have found it, I'm going to see if I can't send it from my screen. Bear with me. And there, I sent it as a PDF, and it says
Okay.
Index of Union Exhibits. It's in
Very
the chat.
Thank you so
Hopefully-
much.
Hopefully you can
Gary, did you
download
get
it
the
and
city's
open it.
exhibit index?
I did get the city's exhibit index. I did.
Okay, perfect.
All right, so Ms. Pfeiffer, are you ready to resume?
Break out to Dr. Pepper.
Yeah, the city's ready.
All right, and Chief, are you ready?
Yes, sir.
All right, Mr. Sventus, are you ready?
Yes, I am.
Then Ms. Schultz, if you're ready, let's go back on the record and continue the cross-examination of the chief. And Mr. Cervantes, you can resume.
Chief, I want to understand correctly. Was it your testimony that none of your officers, I'm sorry, none of your firefighters signed for having received your December 2014 memo? Is that your testimony?
Yes, sir.
Okay. I'm going to ask Naomi to share a screen and we've emailed the document to the court reporter and to Mr. Hartsfield. And my question will be of the witness, the document that we're showing on our screen, have you seen this document before?
Just tell him you can't see it.
Can you have her zoom that in, please? Make it a little bit bigger.
I sure will.
Thank you. What's the date circle there? I can't see. 2014.
You can move closer if you need to.
Okay. Yes, sir.
Okay. So, in fact, you did have employees sign an acknowledgement of your December 9, 2014 memorandum, correct?
Yes, sir, I did.
Okay. So when you testified earlier, it was just lack of memory, not because you were being misleading, correct?
Sir, I would never intend to mislead. It was, again, a lot of information, a lot of time has passed.
And my question said it was lack of memory, not because you were trying to mislead. You would agree with that, right?
Yes, sir, lack of memory.
Okay. And sometimes people make mistakes about memory because sometimes events happen so long ago, correct?
Yes, sir.
All right. So you don't have one of these for David Samano, correct?
Not to my knowledge.
Okay. All right. And I think that we've emailed that to the hearing examiner, to the city, and to the court reporter. And we would like this to be Exhibit 29, if that's the next exhibit. And,
I believe that is your next exhibit number, Mr. Cervantes.
and so we would offer it and ask that it be admitted.
And Ms. Pfeiffer, do you have any objection?
I'd only just object to the relevance because as you can see from the title, it says it's a policy change. And Mr. Fuentes has already indicated that, and Chief has already testified that Mr. Samano was not employed at the time the policy came out. Therefore, he wouldn't be updated on a policy change. It would be a new policy. So the document has no relevance on Mr. Samano.
And
Well,
I'll overrule the objection on relevance and admit appellant exhibit 29. And bear with me while I see if I can't find it here in the emails. I don't have it yet. But I don't want to hold up the examination of the witness. We'll deal with it on a break if I don't have it by then.
All right, so Chief, do you remember a Lieutenant Brandon Griffin being arrested for DWI?
Yes, sir.
And that happened almost at the same time as David Samano. He was arrested on January 30th of 2019 for DWI, correct?
I don't know Brandon Griffin's date, but I do remember the DWI.
All right. And his blood alcohol level was twice the legal limit, correct?
I'm not sure. I don't have that in front of me, so I don't remember that.
All right. And he was a probationary lieutenant, correct?
Yes, sir, he was.
And so he received an indefinite suspension and then a release and settlement agreement, correct?
Yes, sir.
And his settlement agreement was a 75-day suspension, correct?
Yes, sir.
And in addition to the 75-day suspension, if you had so chosen, you could have demoted him as a lieutenant since he was probationary, correct?
Yes, sir.
And you chose not to, correct?
Yes, sir.
All right. Let's see here.
And
Now,
just to remind those, Mr. Cervantes, do you have a page number for that particular discipline or exhibit number?
My understanding is it was not included in this index, but we can email it to you and have it as exhibit. Let's display it on the screen if we can.
I'm sorry, Mr. Hartsfield, I'm gonna have to object. This wasn't turned over in the production of exhibits prior to this arbitration. So these documents, specifically this document, the Brandon Griffin one, should have been turned over in advance if he was gonna use that in his case in chief.
All right, it was turned over to us by the city in Serta's case as part of our request for production, and our request for production was identical in both cases. And in the Serta case, it was marked as exhibits COSA 0163 to 0168.
And the Serta case has no bearing on the Samano case. We're talking two different cases. And what happens in discovery isn't necessarily what's admissible or used at the hearing, and you still have an obligation to turn over the exhibits just as the city did.
Well, I don't think the city can argue surprise since they turned it over to us.
Well,
And
Ms. Pfeiffer,
the witness has already testified to it.
yeah, Ms. Pfeiffer, the witness has already testified to it, and based on the fact that it's in evidence, I'll overrule the objection. I'll admit it conditional, like I've admitted other exhibits conditionally, and you can come back and tell me why I shouldn't rely on it in your post-hearing submission. So if there is a procedural rule somewhere that would keep it out, you can have time to look for it and tell me about it. But in general, I didn't think that either the rules of civil procedure or the rules of evidence apply to this proceeding unless there's something that I've overlooked in either chapter 143, chapter 174, the collective bargaining agreement, or the civil service rules. But rather than you have to go look that up, you can do it in your post-hearing submission and come back and tell me, here it is. You can't consider that.
Well, the Texas Rules of Civil Procedure do apply for the discovery under the CBA, but I'll gladly put that in my post-hearing brief.
All right, that would be helpful because I didn't recall that the CBA picked that up for this proceeding as contrasted with, I thought that was the grievance proceedings, but I could be misremembering what's in the CBA because you do make distinctions between the two processes. And I don't want to hold you to something or hold me to something on the fly when I haven't had a chance to look it up and you haven't had a chance to look it up either. So
Thank you,
I'll
Mr.
admit it conditionally with that understanding. And I believe, Mr. Cervantes, that would be Appellant Exhibit 30. Am I keeping track of the numbers correctly?
Correct. And COSA 0163 through COSA 0168.
And can the court reporter confirm that we're keeping up with the exhibit numbers correctly, that we're now at Appellant Exhibit 30?
Yes, that's correct.
Thank you, Ms. Schultz. You may continue, Mr. Cervantes.
Chief, you agree that you have a blood alcohol concentration of 0.15 or greater in a DWI in the state of Texas. That's a more serious DWI than a DWI between 0.08 and 0.15, correct?
Well, I think all DWIs are serious, sir.
Okay, but in terms of whether it's a Class A or Class B, you understand that it moves up from a Class B to a Class A once you exceed 0.15, correct?
Yes, sir.
Okay. And you are aware that when you issued the suspension to Brandon Griffin, correct?
I don't have that information in front of me.
Okay. I'm not asking you whether you had Brandon Griffin's information in front of you right now, but I'm asking you, you are aware that when you issued Brandon Griffin a suspension, that a DWI as a general proposition of 0.15 or more was a Class A instead of a Class B, correct?
I don't know what Mr. Griffin's blood alcohol was.
That's not what I'm asking you. You knew on April 17th, 2019, that when you have a 0.15 alcohol concentration, that's a Class A misdemeanor. You knew that, correct?
I knew that, but I didn't know what Mr. Griffin's was at the time.
Okay. If you signed the document, you would have known what you signed, correct?
Yes, sir. If I have the document, I'll be able to look at it and tell you.
Okay. I want to circle back to Ms. Parsons. She was assigned to fire prevention, correct?
Yes, sir, until this happened, and then her status changed in fire prevention.
All right. Fire prevention deals with crowding and fire systems in large buildings where people gather, correct?
Yes, sir.
And so the Aztec Theater would have been subject to her, for lack of a better phrase, subject matter of assignment, correct?
Yes, sir.
All right. And she attempted to use her position to re-enter, did she not?
Yes, she did. It's a difference in using your position to re-enter than trying to use your position to get out of something.
All right. And she threatened to close them down, didn't she?
Yes, sir.
All right. So she used her position to threaten the Aztec Theater. Would you agree?
Yes, sir. And she was punished by having that position taken away from her.
Now, you did, whether Chief McManus called you on the night Boldway crashed into a patrol vehicle, you did have conversation with McManus about that accident, correct?
To my knowledge, yes.
And he wanted you to fire that firefighter, correct?
I don't remember that.
Okay. Are you denying that he said that?
I'm saying I don't remember him telling me to fire anyone.
Okay. Now, when Boldway crashed into the vehicle, it caused significant damage to the SAPD police vehicle, correct?
Yes, sir.
It cost several $1,000s of damage, correct?
Yes, sir.
All right. And you agree that had the police officer not jumped out of the way, that police officer might be seriously injured or dead, correct?
Yes, sir.
All right. And let me start going backwards here. I realize that I'm going to ask you to look at Samano 0131, 131. It should be on Barry Ur.
Yes, sir.
And you would agree that he was charged with a felony of continuous family violence, correct?
Yes, sir.
And continuous family violence is a very serious offense, correct?
Yes, sir.
And if it's true, you'd fire such a person, wouldn't you?
Yes, sir.
Okay, but instead of firing Barry Ur, you chose to use a mechanism in Texas Local Government Code Section 143.056, which is to give him a temporary suspension and wait for the outcome of the criminal case, correct?
I'm going to object to relevance. Family violence situation has no bearing on a DWI case, and I'm not even sure where we're going with this.
There's a broader issue here.
Well, I'll overrule the objection and give you a running objection to this line of questioning and allow you to tell me in your post-hearing submission why I shouldn't rely on it. So, Mr. Cervantes, if you go ahead with your questioning.
You agree that you use the provision in Texas Local Government Code Section 143.056, which permits you to issue a temporary suspension and to await the outcome of the criminal case before you decide whether to issue an indefinite suspension, correct?
In this situation, yes.
All right. So he did not receive an indefinite suspension before you issued this document on July 3rd of 2019, correct?
Correct.
And that's because you wanted to find out what facts played out and what the truth would be as a result of the criminal case, correct?
Yes, sir.
All right. Now, on 0126, that's on Maurice Kramer.
Yes, sir.
All right. It's my understanding that you indicated that you could not punish him for the November 17th, 2014 DWI arrest because it was more than 180 days, correct?
Yes, sir.
But you do agree that under 9.03, he had a duty to report an arrest, correct?
Yes, sir.
And under the rules and regulations under 4.02, a firefighter is required to tell the truth, correct?
Yes, sir.
And under 4.03, a firefighter has a duty not to conceal information that he's required to report, correct?
Yes, sir.
And so you can be dishonest by omission. Would you agree?
Would you repeat that, sir? I'm sorry. You broke?
You can be dishonest by omission, correct?
Yes, sir.
And in this case, he was dishonest by omission, correct?
Yes, sir.
And had he reported this DWI, he would have reported to you that he had committed a second DWI, correct?
Yes, sir.
And we know it would have been his second DWI because in Bates 0019 and 0020, we have his first DWI that you addressed in discipline, correct?
Yes, sir.
All right. And in addition to that, he failed to disclose a theft charge as well, correct?
Yes, sir.
And had he disclosed the second DWI, it would have been a Class A misdemeanor because when you have two DWIs, that's a Class A misdemeanor, correct?
To my knowledge, yes.
Okay. Now, let's talk about Geraldine Casals on 0121. You cite how she was belligerent at
Hang on one second. Yes, sir. Go ahead.
You cite on 0122 how she was acting belligerent.
Yes,
correct?
sir. Yes, sir.
And the first time she was acting belligerently towards a male, correct?
Yes, sir.
And then a New Braunfels police sergeant intervened, and when the sergeant intervened, Lieutenant Casals pushed at the sergeant, correct?
Yes, sir.
And you agree that pushing a peace officer is an assault on a peace officer, correct?
Yes, sir.
And if you assault a peace officer, that's a crime, correct?
Yes, sir.
And that can be a felony, correct?
Yes, it could.
And then she took a swing at him, correct?
Yes, sir.
And just because she missed doesn't mean that she did not commit a crime, because an attempt is a crime. Would you agree?
Yes, sir.
So had she connected, it would have been a crime. And if she attempted but failed, that's still a crime, correct?
Yes, sir.
So we know she committed an assault twofold because she pushed him and she attempted to strike him, correct?
Yes, sir.
All right. And then after she was arrested, and she was drunk, wasn't she?
Yes, sir.
And even after she struck at the police sergeant, she continued to be belligerent towards personnel in the Comal County Jail, correct?
Yes, sir.
So from what you indicated there, she was belligerent towards everybody for an extended period of time, wasn't she?
Yes, sir, but she wasn't behind the wheel of a car.
Okay, I got you. All right, so I'm gonna have you look at 0114. And that's firefighter Jesus Cuevas.
Yes, sir.
And I'm going to have you look at 0118. And by the way, this
Are we looking at 114 or 118?
Well, it starts at 114, but I'm going to direct your attention to 118. So when you're at 118, let me know.
Yes, sir.
All right, and so this happened on September 9th, 2018, correct?
Yes, sir.
And so this suspension would have been issued under the same memo of December 2014 that you applied to Samano, correct?
Yes, sir.
And you would agree that Jesus Cuevas was booked for driving while intoxicated with the BAC of 0.15 or higher?
Yes, sir.
And so you understood that to be a Class A misdemeanor, correct?
Yes, sir.
All right. And he was driving his vehicle without a tire on the left rear rim, correct?
Yes, sir.
And so, and he was on the interstate, correct?
That's what it says here.
All right. So, would you agree that driving on the interstate without a tire is highly dangerous?
Driving while intoxicated is dangerous, and driving with a wheel is dangerous also. That's
All right. So that contributes to the danger, correct?
yes, sir.
All right. And the police officer observed him drifting between lanes, correct?
Yes, sir.
And afterwards, um, uh, Cuevas was asked if he had any weapons in the vehicle, correct?
Yes, sir.
And you told us that Rules and Regulations 4.02 says that you are required to tell the truth at all times, correct?
Yes, sir.
And Cuevas didn't tell the truth to the police officers, did he?
I'm not sure what you're talking about here.
Okay. Let me ask you this. Is this one of the guys that you testified? You remember a lot of these guys because you know them?
I remember Cuevas. Yes, sir.
Okay. And is he one of the people you know?
I remember certain people by different things that go on in their lives, but whether he lied on this particular thing, I'm not seeing, so I'm not remembering that.
Okay. You do recall that you alleged that the officer asked if he had a gun in the car, correct?
Yes, sir.
Cuevas denied that, correct?
Yes, sir. I see that now.
And so when he denied that, that was untrue, correct?
Yes, sir.
And so he wasn't being truthful, was he?
Correct.
So he violated rules and regulations 4.02, correct?
Yes, sir.
And honesty is a big factor for firefighters because they oftentimes have to testify in court, correct?
Yes, sir.
And if they're untruthful, the DA may not sponsor them as a witness, correct?
That's correct.
All right, but you did not charge him with violating 4.02, did you?
No, sir.
All right. And when he had a handgun in the car, you understand that if you're obeying all laws while driving and not engaged in any criminal activity, that you can have a handgun in your car. You understand that, correct?
Yes, sir.
But when you're violating the law by engaging in DWI or any other activity, if you're carrying a weapon, then your carrying of a weapon becomes unlawful, correct?
Yes, sir.
All right. So do you believe that it's important for your firefighters to tell the truth to police officers?
At all times.
Okay. But in this case, it was okay for him to lie to the officer?
No, it wasn't.
Okay, did you give him punishment because he lied to the officer? Did that factor in your level of punishment?
No, sir.
So the fact that he lied to an officer didn't factor into your assessment of 75 days?
I think the totality of driving on the rim were some of the other things that factored into it.
Okay, so would lying to the police factor into it with those other things or not?
Yes, it would.
Okay. So you considered the lying as one of many factors when you decided to give him 75 days, correct?
Yes, sir.
So the circumstances surrounding your deciding to give him an additional 15 days from the standard 60 was that he was twice the legal limit, he was driving on his rim, he lied to the police, and he had a handgun. Those four factors contributed to an increase to 15 days, correct?
Yes, those are mitigating factors.
Were they mitigating or aggravating?
They were factors in the decision to give him an additional 15 days.
Okay, but you used the word mitigating, and I just want to make sure that I understand correctly. And
Well, that's why I changed what I said. The factors, as far as the things that you just mentioned, were the reasons he was given 15 days.
okay,
That's it. An additional 15 days.
right. So and I don't want to put words in your mouth, but would you agree those were aggravating factors that increased the level of punishment?
Yes, they increase the level of punishment.
Okay. Now, I want to direct your attention to Samano 0108.
Yes, sir.
That's David Morales, correct?
Yes, sir.
And are you familiar with that intersection as being a location where there's been many severe collisions and fatalities? Given
As
that,
far as Northwest Military and Wurzbach?
yes, Wurzbach Parkway, that's an area where EMS often responds to for serious injuries and fatalities, correct?
I have no idea what the intersection looks like or how busy it is.
Okay. If I were to represent to you that that's one of the more dangerous intersections in San Antonio, do you have any reason to disagree with me?
No, sir.
All right. And so David Morales was intoxicated and he crashed into the rear of a vehicle. Is that correct?
Yes, sir.
All right. And he crashed into the rear of a vehicle because he was unable to recognize that the vehicle was stopped for a traffic light, correct?
Yes, sir.
All right. And you would agree with me that the collision caused significant damage to both vehicles, correct?
Yes, sir.
And the value of damage to both vehicles exceeded the value of any alleged damage in the case of Samano, correct?
I don't have damage numbers, so I'm not sure.
Okay. Did you see photographs of the damage in the Morales case?
No, sir.
Did you read the peace officer accident report where it talks about the amount of damage to the other vehicle?
Yes, but I don't remember that as far as the amount.
Okay. And Morales got 75 days in that case, correct?
Yes, sir.
And the 15-day increase was owing to the fact that he had a collision, correct?
That's correct.
All right. Now, I want you to look at 0091.
Yes, sir.
This involves Stephen Tejeda, correct?
Yes, sir.
And you gave him a 60-day suspension in that case, correct?
Yes, sir.
And you allege on 0092 that when the officer asked for a specimen, that Tejeda refused, correct?
Yes, sir.
And that the officer had to get a search warrant to draw blood, correct?
Yes, sir.
And so the fact that Tejeda refused to cooperate by giving blood and requiring the officer to get a search warrant, that did not cause you to increase the punishment, did it?
No, sir.
All right. So you stuck with the 60-day minimum, correct?
Yes, sir.
So you didn't consider the refusal to cooperate an aggravating circumstance, did you?
No, sir.
All right. Once you go to 0084,
Man, I turned right to the page. That's the first time I turned right to the page. How about that? I'm ready.
you're getting good at it. And before this is over, in just a moment of levity, we'll be dancing, right? Okay, so 0084, I want you to go to 0085. This is a lieutenant, correct?
Yes, sir.
And he got a 90-day out of this, correct?
Yes, sir.
And let's talk about Lieutenant Gomez. This happened during your policy that was in effect for December 9th, 2014, correct?
Yes, sir.
And his blood alcohol level was 0.15 at the time of the arrest, correct?
Yes, sir.
And you've already acknowledged that you understand that that's a Class A misdemeanor, which is greater than a Class B, which is your normal DWI, correct?
Yes, sir.
And he withheld information from you, did he not?
Yes, sir.
And he had a duty to disclose that information, correct?
Yes, he did.
And you've already agreed that when someone holds information from you when they have a duty to do so, that that could be considered dishonesty, correct?
Yes, sir.
But you didn't charge him with being dishonest, did you?
No, sir.
And would you agree that he only disclosed the information when the story was released on the media, correct?
Yes, sir.
And would you agree that the failure to be honest and accept responsibility from the get-go shows a lack of remorse?
I don't know if it shows a lack of remorse. It shows a lack of responsibility.
Okay. So would you agree with me that part of remorse and making amends is acknowledging your wrongdoing?
Yes, sir.
And so if someone is going to make an amends and show remorse, you would expect them to report immediately, correct?
I don't know. I don't know how to answer that.
Okay. Fair enough. All right, let's go to 0064. Ryan Pollock. Would you agree?
One sec. Yes, sir.
All right. You met with Ryan Pollock, correct?
Yes, sir.
And he admitted to you that he was inside the vehicle in question when he was arrested, correct?
Yes, sir.
And he admitted that he was inside the vehicle and had the engine running, correct?
Yes, sir.
And that he admitted that he got out of the vehicle when the officer asked him to do so, correct?
Yes, sir.
And so the officer gave him a break by booking him only for public intoxication and not DWI, correct?
Yes, sir.
And you know that under the law, if you're inside a vehicle with the engine running, our courts consider that operating a vehicle and find that sufficient to prove DWI, correct?
Yes, sir.
All right, so he was guilty of DWI by his own admission, but he got a break from the police officer, correct?
Yes, sir.
So even though he got a break, you did not fire him, did you?
No, sir.
He ended up getting what? Got a 45-day suspension.
Yes, sir.
And he also, according to the KSAT news report, ran over a street sign and damaged it, correct?
Objection. Where is this information coming from?
I just asked a question. He can answer whether he agrees or disagrees.
I don't know. I don't remember that.
All right. And the handgun was also seized from his vehicle, was it not?
I don't remember that either.
All right. Now, Lieutenant Lee Stanfill, you recall him, correct?
Yes, sir.
And would you agree that at Bates 014, that's the first time he gets a suspension for a DWI, correct?
I'm sorry, 014?
Correct.
Yes, sir.
And admittedly, this was in 2010 before you implemented the policy that applies to Samano. You agree with that?
Yes, sir.
And you gave him a 15-day suspension then, correct?
Yes, sir.
Then on at Samano 0017, you deal with him a second time for a DWI, correct?
Yes, sir.
Even though he was charged with a DWI, he entered into a pretrial diversion program, correct?
Yes, sir.
And so even though he was in a pretrial diversion program, you gave him 25-day suspension. So you increased punishment from the one before, correct?
Yes, sir. It's progressive.
All right. Then You dealt with him again. I believe it was 025.
Yes, sir.
And even though he had a DWI in between and got pretrial diversion, this was actually his third DWI, correct?
Yes, sir.
And even though you bumped up the previous suspension to 25 days, instead of bumping it up, you went back to 15 days, correct?
Yes, sir.
All right. And I want you to go to 0024.
Yes, sir.
Just to be clear, Boldway struck 2 SAPD marked patrol vehicles, correct?
Yes, sir.
And you allege that Boldway endangered the lives of 2 officers, correct?
Yes, sir.
And you allege that both were forced to jump over the median to avoid being injured or killed, correct?
Yes, sir.
So even though both jumped over the median, Breanne Martin suffered an injury, a sprained foot. So one was injured, but both had to jump, correct?
Yes, sir.
And they came close to losing their lives that night, correct?
Possibly, yes.
All right. And I want to make sure that I want you to go to Samano 0001 and 0002. And I want you to go to the third paragraph, third line. And I want you to read out that sentence based upon circumstances. Please read that out loud.
0012.
0001. 0001.
Okay, I'm sorry.
Samano 0001.
Okay,
And let me know when you're there.
I'm here.
Okay, so the third paragraph down, third line, it says based upon circumstances. Can you please read that out loud?
Based upon circumstances surrounding the arrest, a release and settlement agreement may be offered to the employee that will include a minimum 60-day suspension as well as rehabilitation and counseling requirements. A second offense for driving while intoxicated will result in termination.
All right. Would you agree with me that in that document, you did not describe what circumstances surrounding the arrest mean?
Yes, sir.
All right. And I think you talked about Samano used profanity in talking to the trooper.
Yes, sir.
You had a firefighter by the name of Chris Johnson that had a Facebook post that was full of profanity. Would you agree with me?
Yes, sir.
Objection on relevance. First off, that document wasn't produced or turned over in this case, and then also, whatever a Facebook post has no bearing on a DWI and the totality of the circumstances in Samano, as the chief has already testified to.
I'll overrule the objection, give you a running objection to this line of questioning, but I'll let Mr. Cervantes make his record, and then you folks can tell me in the post-hearing submissions why I shouldn't or why I should rely on this line of questioning. So, Mr. Fuentes, please continue.
All right, and in his Facebook post, he said, F the police. Would you agree with me?
Yes, sir.
And he said, F the departments and administrations, correct?
Yes, sir.
And that's disrespectful to your fellow department head, William McManus. Would you agree?
Agree, but he wasn't behind the wheel of a vehicle.
I understand. And then he said an extra FU to firefighters, correct?
Yes, sir.
And he said FU to paramedics as well, correct?
Yes, sir.
And then he had an FU to paramedics as well, correct?
That's correct.
And he ended it by concluding with another FU for the police, correct?
I don't have it in front of me, but if you say so.
All right, and you found that highly offensive, did you not?
Absolutely.
And there was no excuse or justification for it, correct?
None whatsoever.
And you understand that Facebook is a medium whereby it gets widespread circulation, correct?
Yes, sir.
And being that it was from a firefighter, destroys and harms morale and credit and repute of your department, correct?
Yes, sir.
But you did not fire him, did you?
He wasn't behind the wheel of a car.
Okay, sir, answer my question. You didn't fire him, did you?
No, I didn't, but he wasn't behind the wheel of a car.
Okay. And I didn't ask you whether he was or wasn't behind the wheel of the car.
He is allowed to fully explain his answer, Mr. Fuentes.
If I can just get you to move along to the next question, Mr. Fuentes, that'll help the process.
Now, in your previous testimony, you indicated that when you arrived in, was it 2007? You arrived in 2007, right?
You completely broke up on me when you leaned down.
You arrived in 2007, correct?
Yes, sir.
All right. And you testified that when you arrived, that there was several stacks of pending discipline for DWI, correct?
There was one stack with some DWIs included, but there's a multitude of different disciplines of discipline.
And you expressed the belief that the previous administration tolerated DWI, correct?
I stressed that there was a lack in discipline, a lack in consistency, a lack in corrective discipline in this organization. There was discipline that was different for EMS and fire, and so there was a lack of consistent discipline in this organization.
All right. And one of the things that you expressed is that you just indicated is that not only did there appear to be inconsistency, but there appeared to be favoritism, correct?
Yes, sir.
And you wanted to eliminate any suggestion of favoritism, correct?
Absolutely.
And if I understand you correctly, the indication of favoritism was that it depended upon who you knew, correct?
Actually, or division that you were assigned to.
All right. And so you would agree that if you're of a higher rank, you should not receive more lenient punishment than someone of a lower rank, correct?
Yes, sir.
I may be finished, but if I can have about a minute, I will ask for, if I can resume at 11:05 or at 11:06.
If we can just go ahead and turn that into 5 minutes so we can, yeah.
I got
stand
a,
up and everything.
I got a new meeting with Eric.
All right. Well, then can we resume at 11:10?
Does that work? And are we on time, chief, or whatever you have to do next?
Yes, sir, we're perfect right now.
Okay, then let's take the 10-minute break and come back at 11:04, I believe, be 10 minutes.
Thank you.
Thank you, sir.
And while everyone is back, I was going to ask before we started back if everyone has gotten the Pelham exhibits 29 and 30. And I believe 29 was the information about a Lieutenant Griffin, and 30 was the redacted receipt for policy. So, Ms. Pfeiffer, have you gotten those?
Yeah, I did receive them, but somehow I wrote them down backwards. If, I don't know which
Well,
one's 29, but.
Well, let's ask the court reporter to make sure. Is the policy sheet that was redacted, that receipt form, was that appellant's exhibit 30?
You know, I don't know because I don't have record of having it being sent. I don't have it. My office probably has it.
Ah,
I couldn't tell you. I can go in there and ask them if they've received it if you want to hold on for a second.
why don't we do that? Mr. Cervantes, do you have a note that the Griffin DWI information was 29 and the redacted policy form receipt was appellant exhibit 30?
But the redacted was before Griffin, but I could be wrong.
All right, well, Ms. Pfeiffer has it that way. Why don't we, Ms. Schultz, when we have a longer break,
Sure.
you can look back in your notes and see what we did, and that way we number it correctly based on the transcript. All right, so with that, are we ready to go back on the record, Mr. Cervantes
Yes.
and Ms. Pfeiffer?
Yes,
All right, then back on the record. And Mr. Cervantes, do you have any additional questions for the chief?
Yes, I do.
All right.
Chief, it's my understanding, and please correct me if my understanding is wrong, but it's my understanding that from time to time you issue summaries of discipline issued to firefighters. Is that correct?
Periodically, yes, we do. We do that. I don't think we've done it in a while, though.
All right. And before David Samano was terminated, from time to time you would do that either quarterly or yearly. Would you agree?
Yes, sir.
And before he was arrested for DWI, you had not published any instances of firefighters being terminated under your December 2014 policy, correct?
I'm not sure when we had done it as far as timeline.
Okay. But before his arrest, would agree that no firefighter had been fired under your new policy for DWI, correct?
Yes, sir.
All right. Now, you've already told us that your memo does not explain what the surrounding circumstances are.
Yes, sir.
After you issued your memo, did you push out either by email or through supervisors an explanation of what surrounding circumstances meant?
No, sir.
All right. Pass the witness.
And Ms. Pfeiffer, do you have any redirect, or do you need a moment to decide if you have any redirect?
I do have redirect. But just 1 second, I have a question for my co-counsel, and I'll step that way so I'm not by the witness, if that's all right.
Sure.
All right, the city's ready to proceed.
Please proceed with your questions then.
Thank you. Chief, I just have a couple for you. I know you came to the city in 2007, but prior to that, have you ever been a law enforcement officer?
No, ma'am.
Have you ever been a lawyer?
No, ma'am.
And then, when you're deciding disciplines, how do you decide the punishment to issue in a situation?
When deciding the punishment, and I never take these lightly. I don't wake up in the morning wanting to give discipline to anybody because I'm really not built that way, and so I spend a lot of time talking to the person, trying to get a Reader's Digest version of the person, and then I look at all the factors that are available to me, whether it's police reports or photos, videos, anything like that, and then talking to that person to try to help me make a decision. You do look for a level of contrition. You look at body language. You look at all of those things when you're trying to maybe get to know somebody on a short period of time.
Do you have a list, like an itemized list that says if someone's cursing, I'm going to give them 5 days. If someone is this, I'm going to give them that?
There's no menu as far as discipline, as far as what we're looking for. It's like, okay, a couple points for this, a couple points for that. We don't have a menu.
You base it on the totality of everything that comes out during the course of your fire department investigation into
I base it on all the factors that are revealed during the investigation by the department, by law enforcement, and we take all of those factors into consideration.
Now, Mr. Cifuentes went into a lot of disciplines during that questioning, and I don't want to go through all of them, but looking at Samano 005 through Samano 0051, so that's Connolly through Wolf, all of these disciplines are prior to the enactment of the DWI policy in December of 2014, are they?
Yes, ma'am.
So none of them have any bearing on how you discipline Samano?
No, ma'am.
Okay. And then, looking at Samano 0126, it starts with Engineer Bramer and goes through Samano 0142. Oh, I lied. I forgot Appellant 28. Okay, so 0126 through 0142 plus Appellant 28, which is Darla Parsons. All of those disciplines were after the change in the policy in March of 2019, correct?
Yes, ma'am.
So none of those have bearing on Mr. Samano's case?
No, ma'am, none whatsoever.
And I know Mr. Fuentes talked a lot of you about these certain cases, and one of them was Darla Parsons.
Yes, sir.
And I believe you testified, and correct me if I'm wrong, but Darla Parsons had a specialized position with the department. Is that right?
Yes, ma'am. Darla Parsons was a fire prevention inspector, and she'd also do a lot of the events downtown as far as providing a fire prevention specialist at these events. Because of the discipline, she was removed from that position to where she'd be unable to act in that function again.
Okay, so in addition to the 30-day suspension she received, she also was her job position changed because of her action.
Her job position changed, overtime opportunities changed for her. So yes, ma'am.
And then with Drury, did he also hold a specialized position?
Drury was a member of our special operations unit, working out of Station 51, jury was eligible for different opportunities in overtime, potential deployments on flooding incidents, boat team incidents, urban search and rescue incidents. That's a very highly sought after and specialized position. He was removed from the team.
Okay. So he also had, in addition to his suspension, an additional, I won't call it a discipline, but a change in his circumstances of his job because
Yes.
of his actions.
Absolutely.
Right. When you looked at the Samano case and you decided to proceed with an indefinite, why did you do that?
It's extremely hard to take someone's job away from them. And as I mentioned before, we don't take this lightly. Out of every discipline I've ever had in this organization, Mr. Samano had more issues than anybody I'd ever seen in one incident. Beside the DWI, when he knows the dangers of driving and people that he was with that night tried to provide options for him, he chose to drive anyway. When he was pulled over, he lied about a relationship with the district attorney. When he was pulled over, he used the F word to the officer. He was belligerent. He kicked in the officer's dash. And then on top of that, fire units had to respond, in which they wrote letters also on his behavior. So the total of all of those things were the reasons that I came to the conclusion that Mr. Samano did not deserve a second chance on this fire department.
And do you stand by that decision today?
Absolutely.
And in all the cases or discipline cases that Mr. Cifuentes talked to you about, I know there's a lot of them, do any of them combine all of the things that you've seen with Samano in one case?
None of them were the perfect storm of events that we saw with Mr. Samano, but again, if any of those would have been behind the wheel, they would have been terminated also.
I'll pass the witness.
I want to make sure that units 1 through 30 by the agreement have been admitted. And we would offer them for admission if they haven't.
And I believe that I've admitted them conditionally, as we discussed at the very beginning. But I do want to make sure we've got the right numbers assigned to 29 and 30. So why don't we go on the record for a moment and let the court reporter go back and look at our notes and see what was assigned to the Griffin discipline and what number was assigned to the redacted policy receipt.
May I offer a suggestion? I believe we presented the redacted first and then Griffin second. And I would just simply say we follow the sequential order of when they were presented, whatever that might be in the record.
And I think you're right. I think when I look back at my notes more carefully, it looked like we did the policy redaction, or the policy receipt that was redacted is 29 and the Griffin is 30. And Ms. Pfeiffer, I think that agrees with your notes as well.
Yes, it does, sir.
All right, then we'll go with that, that's what we did. And if you'll give me a moment, let me mark my notes in. Let me save those documents on my computer with that designation. So give me just a moment to do that. All right, that's accomplished. That does lead me to have another question about something that was in the email that you sent to me, or your staff sent to me, Mr. Cervantes. So since we're taking a break from asking questions, let me address that matter and let me find that email. One of the emails had COSA's response to Samano's request for production. Is that something you're intending to offer, Mr. Cervantes?
I'm sorry. What was the question?
Your staff in the email, one of the documents sent was COSA's response to Samano's request for production. Is that another exhibit, or that just happened to be something that was sent to me?
That's not an exhibit.
Okay, then
Mr.
I'll
Hartsfield?
ignore that.
It seems like we're getting into more administrative matters. Are we done with Chief Hood?
Well, I was going to say, Mr. Cervantes, any more questions for the chief?
No. Have a good day, Chief.
And Ms. Pfeiffer, any more questions for the chief?
No.
Thank you, Mr. Fuentes. Mr. Hartfield, thank you.
Thanks for your time, chief. And Ms. Pfeiffer, do you have another witness to call, or do you need a moment to decide if you have another witness to call?
The city's going to rest, sir.
All right, so the city is resting subject to any rebuttal. And Mr. Cervantes, do you have a witness to call? You want to take a break for lunch to decide if you have a witness to call? What's your pleasure?
We're ready to proceed.
All right, then if you'll call your witness.
We call David Samano.
And if I can have the court reporter swear in the witness.
Would you raise your right hand, please? You solemnly swear the testimony you're about to offer in this case will be the truth, the whole truth, and nothing but the truth, so help you God. And then you
All right. Can you please state your full name?
Oh, but we couldn't hear his answer.
I don't hear him.
Yeah, I can read your lips that you're saying I do, and it looks like your audio's on. Try again.
It's not working.
I'm going to ask the staff to go assist him in unmuting his microphone.
Sure, or turn up the volume on his microphone, because that may be it, because it's showing that his microphone is on.
Can you hear me now?
Yes. So
Okay.
why don't we redo it and let the court reporter give the oath again, and that way we can hear Mr. Samano. So Ms. Schultz?
Would you raise your right hand, please? Do you solemnly swear the testimony you're about to offer in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Samano, can you please state your full name for the record?
Yes, sir. It's David Roy Samano.
And you're the grievant appellant in this case?
Yes, sir, I am.
All right. And you were a San Antonio Fire Department employee, is that correct?
Yes, sir.
What was the date of your hire?
August 2017.
And you appealed this indefinite suspension, which is why we're here today, is that correct?
Yes, sir.
All right. And you've seen the letter that's been introduced in this case, Samano Exhibit 001 and 002, which is the letter from Chief Hood dated December 2014. You've seen that today, correct?
Yes, sir.
When you were hired, did anyone provide you a copy of that letter?
No, sir.
Did anyone provide you a copy of that letter before you were terminated?
No, sir.
And you were in fact arrested for DWI, correct?
Yes, sir.
Tell the hearing examiner, Mr. Hartfield, what happened in court to resolve the case.
The ultimate decision from the judge was charging me of obstruction of highway.
And so you did not hear a plea of guilty to DWI, you entered a plea to obstruction. Is that correct?
You said I did not plead guilty to what, sir?
DWI, you pled to obstruction, is that correct?
I did not plead guilty to either one of those.
Okay, and what happened? Were you placed on probation or deferred for obstruction?
Yes, sir.
All right. And were you ever charged with criminal mischief?
No, sir.
All right. After you were arrested, did you make an attempt to go see the trooper that got us at his substation?
Yes, I did, sir.
Describe to Mr. Hartsfield what you attempted to do to make contact with him.
Well, first, when I was released from jail, I knew that one thing I knew I wanted to do was to let the officer know that I was extremely sorry about what happened that night, that was totally out of character. And I definitely wanted him to know that I was apologetic and I was sorry. So I found out which substation he worked at. I believe I called, I don't think it was the first substation I may have called, but I found out where Mr. De La Garza worked and asked if I could go by and deliver an apology letter to him because they said that he was really not there at the substation all the time. He was rarely there because he was out on shift. So I proceeded to write a letter and I took it over to his substation and gave it to the clerk that was on duty that day.
Okay, can I ask the city to shut down their COSA witness screen? I think that is contributing to audio glitches.
I can't turn the audio off, or I can't object if I need to.
No, the COSA witness screen.
We turn the video off for the close to witness, yes, but I can't turn the audio off for all of it because it is my ability to object.
Okay, well, the audio for the COSA witness is different from your audio, is that?
No, it's all the same audio.
Okay, all right. All right. So you attempted to apologize by going to the substation. Tell us what happened.
I hand delivered an apology letter to the clerk there because Officer De La Garza wasn't at the substation at the time.
Can you tell Mr. Hartsfield whether you offered to pay restitution for the damage that you were accused of causing?
Yes, I did, sir. I actually attempted to call Officer De La Garza's supervisor at least 2 or 3 times just to, once again, let him know the situation that I wanted to try and make things right. And, like I said, I simply called him each day to see if he had found out anything new in regards to possible restitution. But the supervisor told me that nothing was ever filed. And so that he didn't think that anything was going to be reported.
All right. As part of your plea to the obstruction, were you asked to make restitution for any damage to a patrol car?
No, sir.
All right. And did you make these attempts to apologize to make restitution for the alleged damage prior to meeting with Chief Hood?
Yes, sir.
And when you met with Chief Hood, did you explain to him that you made attempts to apologize and make restitution to the trooper?
Yes, sir.
And today, can you tell the hearing examiner whether you have remorse for your conduct on the day that you were arrested for DWI and what you are doing today.
Absolutely. I still have remorse to this day. I still wish that I could apologize to the officer in person. And right now I'm currently working for another fire department.
All right. Past witness.
Ms. Pfeiffer, any cross, or do you need a moment to decide if you have any cross?
Well, I do have cross, but it's already 11:43. Do we want to break for lunch before I get started? So we don't have to break in the middle?
Mr. Cervantes, do you have a preference?
Well, if we can finish in less than an hour, I would prefer that we push on, but if it's going to take more than an hour, I suppose we could break for lunch.
And Ms. Pfeiffer, your notion, do you have, how much cross-examination do you have in terms of time?
Well, I can't guarantee how long I'm going to question Mr. Samano, but I am going to need to eat probably around noon. So I request the break.
All right, and then just for timing purposes, Mr. Cervantes, do you have another witness after Mr. Samano?
I'm 99.9% certain I do not.
All right, and does that make any difference to you, Ms. Pfeiffer, as to whether we proceed or break for lunch? And I'm happy to break for lunch if you want.
I just like to break for lunch. I don't think I can wrap this up in 15 minutes, and I tend to get hangry, so I don't want that to come out on anybody.
I don't want anybody to go without lunch if they need to have lunch. So how long do you want for lunch? You want an hour,
Just an hour.
45 minutes? What works for you?
Just an hour.
All right. And Mr. Cervantes, is an hour enough for you for lunch? Because I know you had some problems yesterday with ordering.
I think what we'll do is we'll order Jimmy John's because I think they're faster.
Okay.
That's not an endorsement.
I understand it's not an endorsement of the quality of food. It's just an endorsement of their more prompt. All right. So with that, it's 11:45. So we'll plan to get back at 12:45. And is that enough time for you, Ms. Schultz?
Yes.
All right. So we'll go off the record and resume at 12:45. Thank you.
Thank you.
Hmm. go. Well, what? Okay. And Ms. Schultz, did you have enough time to eat?
I sure did. Thank you.
And your connection, audio and video is fine?
It's fine. I kept hearing on theirs, though. It must have been the cities. I'm not sure where all that noise was coming from.
But you could hear everything?
I could hear, yes.
Okay. Well, if you have any problems, just let me know and we'll track
Appreciate
it down. Because it's easy, I found that folks may move their cell phone close to a speaker and that is just close enough to cause some feedback.
Right, it does.
So especially after taking a break, that's always possible that happens.
Yes. Will you be asking them on the record for their transcript orders? I don't know if y'all clear that up. Sometimes you do, sometimes you don't.
I don't think they have, but we certainly can do that, or we can take a break and you can ask them, whatever works for you.
Yeah, it's best to do it on the record because especially now with Zoom, otherwise I'd have them sign something. And since we're not present, we try to get it on the record.
Okay.
I appreciate it. And sometimes they have some sort of, I don't know, agreement that the city pays for or somebody pays for half. And I don't know if that's something you cover as the arbitrator.
No.
Sometimes it's discussed. Sometimes it's not. There's nothing absolute about that.
Yeah, I just know they've been using your reporting firm for all the hearings I've conducted. So for all I know, there's a special deal and they get a reduced rate because they send all the work to you folks. I don't know.
Oh, yeah, no, we don't do special rates for that. But anyway, that's fine. Maybe they'll tell us.
Well, I guess I shouldn't have said that because I think there are some reporters out there who do that if they get the work
Yeah,
guaranteed.
I don't think we do that. But then again, I don't handle any of that.
And Ms. Pfeiffer, are you ready to resume?
Yes, sir.
And Mr. Cervantes, are you ready to resume?
Yes, but Jimmy John's isn't as fast as I thought. Still haven't gotten here, but we can press on.
All right, well, if we need to stop so you can get your food order and have a chance to get a bite to eat, feel free to say so.
I think
And
we can press on.
Is the witness ready to begin cross-examination?
Yes, sir.
All right, then let's go back on the record, Ms. Schultz, and Ms. Pfeiffer, you may begin your examination.
Thank you. Mr. Samano, my name is Rosa Pfeiffer. I represent the city of San Antonio. Do you understand that?
Yes, ma'am.
Okay. I'm going to ask you a series of questions today. If for some reason you can't hear me or you don't understand my question, will you go ahead and let me know?
Yes, ma'am, I will.
Thank you. And just so you know, if you happen to answer in a uh-huh or a nod or something, I may ask you to clarify, is that a yes or a no? But that's not to be rude. It's just to go ahead and get everything clear for the court reporter. Do you understand that?
Yes, ma'am, I understand.
Thank you. You started with the San Antonio Fire Department in August of 2017, is that right?
That's correct, ma'am.
And prior to working for the San Antonio Fire Department, you worked for the Corpus Christi Fire Department.
That is correct. Yes, ma'am.
How long did you work for the Corpus Christi Fire Department?
I started in with Corpus Christi Fire in November of 2009.
So from November of 2009 until the date of your termination with the San Antonio Fire Department, you had been a firefighter for approximately 8 years? No, 10 years.
2009 to 27 or to 2019. Yes, ma'am. 10 years total.
Okay. And in that time as a firefighter for approximately 10 years, you've been called out on hundreds of calls?
Yes, ma'am. You could say that. Yes, ma'am.
Those calls included car accidents.
Yes, ma'am.
Some of those car accidents that you were called to as a result of a drunk driver.
I can't recall offhand like if I made a specific call like that, but I'm sure I have in the course of 10 years. Yes, ma'am.
You understand the devastation a drunk driver has the potential to create.
Yes, ma'am, I do.
And that devastation can include serious injury or even death to an innocent bystander.
That's correct.
You understand, excuse me, that it is against the law to operate a motor vehicle while being intoxicated.
I do. Yes, ma'am.
You don't need a policy to tell you that. You just know that, right? That's the
Yes,
law.
ma'am. It is against the law. Yes, ma'am.
So let's talk a little bit about January 31st of 2019. You made a choice that day to go out and drink with some buddies from work, right?
Yes, I did.
And while you're out there, you made a choice to then consume some alcoholic beverages.
I did. Yes, ma'am.
And after consuming those alcoholic beverages, you made the decision to drive your vehicle home.
I did. Yes, ma'am.
Despite the fact that your fellow firefighter said, oh man, maybe we should take an Uber or some other alternative means of transportation.
That night, I recall them saying that they were going to be using that service, and they asked me if I was, I believe, if I recall correctly, they asked if I was okay, and at that point, I said I was okay.
So they were going to use the service, but you decided to drive your vehicle.
I had driven to the location, and they hadn't, so they didn't have any other means other than that to get home.
Okay. But the answer to my question then is yes, they were using alternative means and you were driving your own vehicle.
Yes, ma'am, that's correct.
So after making the choice to consume alcohol and then drive your car or your vehicle, you're then pulled over by a DPS trooper. At which point then you make the decision to call this trooper name, don't you?
I don't recall exactly everything that I said to the trooper. Based off of his testimony, he said that I stated some names to him. Yes, ma'am. That's what he said in his report.
And you don't remember the details of that event because you were intoxicated, correct?
That's correct. Yes, ma'am.
So you have no reason to dispute that Trooper De La Garza, when he testified, that you called him what I'm going to call the F word.
I don't remember saying those things.
And you have no reason to dispute then that you called him, let me make sure I get it correct. Oh, here we go. You accused him of being a fake ass cop. Do you remember that?
No, ma'am, I don't.
Okay. Do you have a full set of the city's exhibits that we've been referring to today and yesterday?
I have copies. Yes, ma'am.
Okay, and you have a physical copy in front of you?
You can tell me in the binder where to look and I can find it. Yes, ma'am.
Okay, perfect. If you would then turn to tab number 3.
Are we looking at the COSA exhibits or the union?
The city exhibits number 3, it will be bait stamp starting on 006. Or 0006, 3 zeros and a 6.
You said it was tab 3?
3? Yes.
Yes, ma'am, I have that here.
If you turn to, it's 8008 for me.
Yes, ma'am. I'm there.
Look, okay, excellent. And then look at number 17, please.
Yes, ma'am.
Read that paragraph to me, please.
Number 17 states, at this point, Samano became belligerent towards me. Samano went as far as calling me a security guard, along as accusing me of being a fake ass cop. He also called me a faggot numerous times. Samano was extremely upset that he went as far as to wish that I prayed that I never need his services because he would not help my family or myself.
And do you agree or disagree that you did these things on number 17?
I don't remember saying these things to him. No, ma'am.
All right, and how about on 18? Go ahead and read that to yourself a little bit, and then let me know when you read it.
Yes, ma'am, I read it.
Do you recall telling the trooper that you knew the district attorney and you were going to get these dismissed?
No, ma'am, I do not.
Now, you've mentioned a couple times that you don't remember saying these things. Are you saying they're untrue or that you just don't remember?
I'm saying that I don't remember, ma'am.
All right, look at number 19 for me and go ahead and read that out loud.
Number 19 states, during this time, Samano also began to kick inside of my patrol unit, causing damage to the air vents of my patrol unit, along with striking the front windshield. He was also able to kick the watch guard camera system inside. The watch guard camera system needed to be restarted after the booking process.
Do you have any reason to dispute that's not true?
I don't remember kicking the camera system. I do remember striking the dashboard with my feet. I remember that the area in there was really small. I'm a bigger gentleman, and I believe at that point I was starting to have my panic attack. So that may have been the reason why I was kicking inside that small space, but I do not remember kicking the watch guard camera or the windshield.
And nothing, do you have any reason today that would affect your memory or your ability to recall any like medical condition or on any medications or anything?
No, ma'am.
And turn back a page for me on Tacosa 0007.
Yes, ma'am, I'm there.
Okay. And number 6 says, I asked Samano if he had been drinking, and he replied yes earlier. Did I read that correctly?
Tomorrow, if you have been drinking, yes, sir. That's correct. Yes, ma'am. That's what he wrote.
And do you have any reason to dispute that that's accurate?
I have no reason to dispute that, no, ma'am.
Do you remember the Trooper De La Garza having you perform the field sobriety test?
I do not, ma'am.
So you don't remember being unable to follow his instructions during that time?
No, ma'am.
And do you remember refusing to provide a breathalyzer sample?
When did I refuse to provide the breathalyzer sample?
I'm asking if did you provide a breathalyzer sample?
No, ma'am. He did not have a breathalyzer with him.
And when you get back to the jail, did you provide a breathalyzer sample there?
No, ma'am. It was my understanding that we did a blood draw.
Do you recall refusing to voluntarily do that blood draw?
No, ma'am. I do not.
Okay. Sir, go ahead and turn to City Exhibit tab 4. It's COSA 0011.
Zero, 0011. Yes, ma'am. I'm there.
Okay, go ahead and turn one more page to 0012.
Yes, ma'am. I'm here.
This is the results of that blood draw that the trooper obtained from you, and the results say 0.120. Do you see that?
Yes,
About
ma'am. I
halfway
do.
down the sheet.
Yes, ma'am.
Now you're aware that's over the legal limit, correct?
I do. Yes, ma'am.
Now, just a few minutes ago, you kind of suggested that the reason that you were kicking in the car was because it's an enclosed space. Are you suggesting that had you been in a more open area, you would not have behaved in such a manner?
No, ma'am.
And you also suggested that about that time, that's when you were having the panic attack, as you identified it. What was causing you to have a panic attack?
I think it was just the entire scenario, knowing, what I did was wrong, knowing the fact that my job was going to be involved, my family was going to be involved, that just all those things together, I feel like is why that happened. Yes, ma'am.
So you mentioned that you knew your job was going to be involved. You knew there was a possibility of you losing your job.
No, I do not. Or no, I didn't.
During the course of that event, do you recall, you clearly recall a panic attack. Do you recall asking or complaining of chest pain?
I can't recall completely. I remember once again that I started having the attack and EMS being called.
Okay. And you remember EMS showing up at the scene?
I remember EMS being there.
All right, and you know that the EMS and fire personnel that responded to the scene, you heard a couple of them testify during the course of this arbitration, correct?
Yes, ma'am, I did.
Okay. And specifically, Engineer Aguilar, he testified and provided a memo that, you know, he advised you that based on your display of behavior, that you'd be lucky to keep your job. Do you recall him telling you that?
No, ma'am, I don't.
Do you have any reasons to dispute his testimony and statement that in fact happened?
I'm just saying that I don't remember him telling me that.
Yeah. You talked a little bit about what's happened with your criminal case. And so after being arrested, you were ultimately charged by the state with driving while intoxicated and obstruction. Is that right? Of a passageway, I believe?
What was the first part that you said? I was charged with what?
Initially, you were charged by the state for driving while intoxicated and obstruction of a passageway. Is that correct?
No, that's not correct.
Okay. I'm going to go ahead and have you turn to COSA number 12.
I'm here, ma'am.
Thank you. All right, so we're looking at number 12 here. This is what's called a complaint. Do you see that at the top?
Yes, ma'am.
And this complaint charges you with the offense driving while intoxicated. Do you see that?
Yes, ma'am.
And then if you turn to 2 pages to COSA 0029,
Yes, ma'am.
we have, this is called an information. Do you see that?
Yes, ma'am.
And I don't know how familiar you are with the criminal process, but an information sheet is kind of like a charging document. So on
Okay.
count one there, it says, on or about the 31st day of January 2019, you did operate a motor vehicle in a public place while intoxicated. Did I read that correctly?
Yes, ma'am.
Okay. And then count 2 goes on to talk about how you, without legal privilege and authority, intentionally, knowingly, and recklessly obstructed a highway and or street. You see that?
Yes, yes, ma'am. I read that. Yes, ma'am.
Okay. So when I say obstruction of a highway or passageway, that's what I'm referring to, that count number 2, correct?
Yes, ma'am.
Well-
Based off of what I see here, yes, ma'am.
Okay. Just want to make sure we're on the same page there.
Yes, ma'am.
All right. go ahead and turn, well, let me ask you this. Ultimately, the charge of driving while intoxicated was dismissed. The state didn't pursue that, correct?
That is correct. Yes, ma'am. They dropped that, and they also dropped the criminal mischief.
Okay, and part of that deal was that you entered in a plea of guilty to the obstruction of a passageway.
What I remember being at court that day was that the judge specifically telling me that I remember going up there and saying that I was going to plead to the obstruction of passageway, and he proceeded to tell me that I'm not going to convict you of anything today. If you stay out of trouble, then everything would get dropped.
Okay, and we'll definitely get into that, because that's what they call a deferred adjudication. You took that, right?
I don't remember that term being used.
Okay. Let me ask you this. Were you represented by counsel in your legal proceeding?
At my DWI hearing, ma'am?
Yes.
Yes, I was.
Okay. So go ahead and turn to me to COSA 0035.
Yes, ma'am.
Okay. And start with the paragraph that says I, and then fills in David Samano, the defendant. And go ahead and read that 3 little tiny paragraphs for me.
Yes, ma'am. I, David Samano, the defendant, being present in court in person, hereby waive the reading of the information in the above numbered and styled cause. You want me to continue?
Please.
I understand that I am charged with the offense of obstruction of a passageway. I hereby enter a plea of guilty to this charge. I am informed by the court as follows.
Okay. And then skip down and read paragraph 4 for me.
Yes, ma'am. If I am entering a plea of guilty to this charge, it is because I am guilty and for no other reason.
All right. So here you pled guilty to the obstruction of a passageway. And you signed that document on page 0037. Is that correct? That's your signature?
Yes, ma'am.
Okay. And then under that is the attorney of record for you. They signed it as well.
Yes, ma'am.
So as part of that plea deal, where you pled guilty, you pled to guilty to count 2. So if you turn back to 0029 for me.
Yes, ma'am.
Okay. Go ahead and read count 2 out loud for me.
And on or about the 31st day of January 2019, David Roy Samano, hereinafter referred to as defendant, did without legal privilege and authority intentionally, knowingly, and recklessly obstruct a highway and street to which the public or a substantial group of the public had access and other places used for the passage of persons and vehicles by rendering impassable and by rendering passage unreasonably inconvenient or hazardous to wit, by then and there operating a motor vehicle while intoxicated against the peace and dignity of the state.
Thank you. So that's what you pled guilty to. You understand that?
Yes, ma'am.
And you see there where, on the last sentence where it says to wit, by then and there operating a motor vehicle while intoxicated. So you understand that you pled guilty to operating a vehicle while being intoxicated, even though the count itself was for obstruction of a passageway.
Based off the terminology here, yes, ma'am.
And as part of the plea deal you took, excuse me, the plea agreement, it starts on COSA 0031, but specifically I'm going to look at 0033.
Yes, ma'am.
You were charged a fine of $600 as part of this deal, correct?
Yes, ma'am.
You were granted a deferred adjudication for a period of 16 months.
Where is that listed on here?
It's under general conditions, 1, 2, 3, 4 down.
Oh, yes, ma'am.
Okay. You got 48 hours of community service.
Yes, ma'am.
You had to pay restitution to the police.
Yes, ma'am.
Okay. Excuse me. You also, under DWI conditions of supervision, you had to attend a DWI education program,
Yes, ma'am.
a DWI victim impact panel,
Yes, ma'am.
a TAIP evaluation and follow recommendations,
Yes, ma'am.
and 8 months of an ignition interlock on your vehicle.
Yes, ma'am.
And just so I'm clear, this vehicle ignition interlock is basically a breathalyzer inside your vehicle, correct?
Yes, ma'am, it is.
Now, what was the restitution for that you paid the police?
I can't recall. I know that that wasn't for DPS though.
I'm sorry, you said it was not for DPS?
I don't believe so, no, ma'am.
So if I'm reading this sentence correctly, it says restitution to TX, DPS, and SAPD. Did I read that incorrectly?
No, you did not, ma'am.
Okay. Excuse me. All right, so go back for me to COSA 007, please, and let me know whenever you're there.
Yes, ma'am. I'm here, ma'am.
Okay. When I was talking to you a little bit earlier about the arrest, I asked you if you knew at that time that you were going to lose your job. Do you remember what you told me?
I didn't think that didn't cross my mind that I was going to lose my job. I just knew that my job was going to be involved somehow.
Go ahead and read paragraph 14 out loud for me.
I advised Samano that he was going to be placed under arrest for driving while intoxicated. I asked Samano to turn around and place his hands on top of my patrol unit's hood. He also began to attempt to persuade me to release him since he knew he was going to be arrested, and in doing so, he would be losing his employment with the San Antonio Fire Department, and he also had an understanding of getting arrested.
Do you have any reason to dispute the DPS trooper's documentation right there?
I don't remember saying that.
Okay. Did you know the DPS De La Garza, the trooper, prior to being arrested by him?
No, ma'am, I did not.
So there'd be no way for him to know you were a member of the San Antonio Fire Department unless you told him.
I'm not sure. He may have seen something in my vehicle to know that beforehand, but I'm not sure on that.
As part of your onboarding with the San Antonio Fire Department, you were provided with the San Antonio Fire Department rules and regulations, were you not?
I believe so, yes, ma'am.
And just so you can follow along with me, I'm on tab 13 of the city's exhibits. If you want to turn there, it's COSA 0045.
Yes, ma'am.
Specifically, I'm going to look at COSA 0047 and 2.01. It says responsibility to know laws and procedures, and under that it says laws and ordinances. B is written directives, C is penalty for violation, and D, lack of knowledge. Do you see that?
Yes, ma'am, I do.
Okay. And under D, lack of knowledge, it says that a lack of knowledge of any of these rules or regulations is not a defense to any disciplinary action. Do you see that?
Yes, ma'am, I do.
Okay. It also talks about lack of knowledge of your roles and responsibilities, your administrative orders, directives, and policies or procedures. That you have then an obligation to understand and familiarize yourself with these rules and regulations, do you not?
Let me just read that really quick, ma'am. It says on there, a reasonable opportunity to become familiar with the rules.
And at the time you were arrested for driving while intoxicated, you had been employed by the San Antonio Fire Department for a period of approximately 2 years. Is that correct?
Yes, ma'am.
So 2 years is an opportunity to be able to learn these rules and regulations. Wouldn't you agree it's reasonable?
I suppose so, yes, ma'am.
Okay. And then 2.02 says abide by the laws and departmental orders, and then A goes into laws. You have to abide by the laws of the United States. So you've already testified that you knew it was against the law to drive while intoxicated, correct?
Yes, ma'am, that's correct.
So you know, based on the rules and regulations, that a violation of that law of driving while intoxicated is in fact a violation of your rules and regs as the San Antonio Fire Department.
The rules and regulations of the fire department, no, I'm not, no, ma'am.
Okay,
I'm not,
I may be asked it in a bad way, so I'll rephrase it, Mr. Samano, because I'm not trying to trip you up here. 2.02A says, it says laws, members shall abide by the United States and the state of Texas and ordinance of the city of San Antonio. Did I read that correctly?
yes, ma'am.
Okay. So do you understand that then as a member of the San Antonio Fire Department, you are responsible for following the laws of Texas?
Yes, ma'am.
And one of the laws in Texas is you cannot drive while intoxicated.
Yes, ma'am.
So by doing so, by driving while intoxicated, in addition to violating that law, you also violated the San Antonio Rules and Regulations 2.02A.
Based off of what is written here, yes, ma'am.
All right. All right. Sir, if you'll go ahead and turn to me COSA 001, and let me know whenever you're there.
Yes, ma'am, I'm here.
Okay, this is the notice of indefinite suspension that you received from the fire department, correct?
Yes, ma'am.
I'd like to talk to you a little bit about the rules that are cited there. Now, we already went through 2.02A under the rules and regs, but you see that's the same one we've already talked about, right?
Yes, ma'am.
Okay, so let's go on then to 3.01, conduct and behavior. Take a moment and read that for me, and let me know when you're finished.
Yes, ma'am, I'm finished.
So in that rule, whether you're on duty or off duty, you have to be basically behave in a reasonable way and be good conduct and good behavior, correct?
Yes, ma'am, that's correct.
So when you're calling the DPS trooper names and insulting his position, calling him security guard and names of that nature, you're not behaving with good conduct, were you?
No, ma'am. I realized I was unprofessional that night, and once again, I'm extremely apologetic about that.
Okay. So you'd agree with me then that the violation of conduct and behavior 3.01 is an accurate representation of your actions that evening?
Yes, ma'am.
And if you go ahead and turn the page to 002. 002 starts, the top one is listed 4.07, negative public image. Members shall not engage in activity tending to create a negative public perception of the fire department. Did I read that correctly?
Yes, ma'am.
And would you agree with me then that driving while intoxicated creates a negative public image for the fire department.
Yes, ma'am, it does.
And that your behavior that night towards the DPS officer would also create a negative perception.
Yes, ma'am.
All right. And then 4.09, use of intoxicants. B, intoxication. Members shall not at any time be intoxicated while on duty. No member shall report to duty while exhibiting the odor of intoxicants or any of the elements, effects, behavior, and appearance of intoxication. And then read that next little section for me.
Members shall not, under any circumstances, be intoxicated while in public to the extent that may damage the reputation of the department.
Do you agree with me then that you were intoxicated on the night of January 31st, 2019 to the point where it damaged the reputation of the department?
I was intoxicated that night. Yes, ma'am.
So then if I understand your testimony correctly, you agree with me that every violation that was alleged within the rule violation that was alleged in the notice of indefinite suspension 2.02A, 3.01, 4.07, and 4.09B, you've admitted to all of those rule violations today.
I was, once again, unprofessional that night. I, again, am super apologetic on all those. And yes, all of those fit under how I behaved that night. Yes, ma'am.
And I definitely understand that you're apologetic today. I just need you to answer yes or no. Do you agree with me then? Are you testifying that you did in fact violate all the rules that were alleged in your final indefinite?
Yes, ma'am.
All right, I'll pass the witness. Thank you, Mr. Samano.
Yes, ma'am.
And Mr. Cervantes, are you ready to redirect or do you need a few minutes?
Oh, I'm ready. Mr. Samano,
Please proceed.
there, when you went to DPS, you went to apologize to the trooper, is that correct?
Yes, sir.
And you informed the chief of your attempts to do so, correct?
Yes, sir, I did.
You informed him of that when you did meet with him before he decided your fate in terms of termination, correct?
That's correct, sir. Yes.
All right, so the city attorney went over some paperwork, and I want you to go over to city exhibit, which goes to 0033, and let me know when you're there.
Yes, sir.
This is a document signed by your defense lawyer, signed by the DA, and signed by you, and signed by the judge, correct?
One moment, sir. You said 33?
Yes.
Yes, sir. Okay, I'm there. Yes, it's signed by myself, my defense attorney, the assistant DA, and the presiding judge.
All right, and at the bottom by the judge says approved and so ordered.
Yes, sir. Approved and so ordered. Yes, sir. I read that.
All right, and under plea, it says that the check is no contest, correct?
Yes, sir. That's correct.
And you would agree that the checkbox of no contest is different from the other paperwork that was brought to your attention, correct?
Yes, sir. That's correct.
And you were asked questions about the $60 ordered in restitution. Do you know whether that $60 was the cost of the blood test that was conducted by DPS?
I can't confirm that, but once again, I'm almost 100% positive that $60 did not go towards restitution for any damage to the vehicle.
Okay. So you don't know whether it was for the cost of the drug test. Or the
That's
blood.
correct. That's correct, sir.
Ask the witness.
Just one moment, Mr. Hartsfield.
Sure.
I have no further questions.
All right. Thank you, Mr. Samano. Mr. Cervantes, do you need a moment to decide if you have another witness to call, or are you ready to rest?
We rest.
All right, so the appellant has rested. Ms. Pfeiffer, do you need a moment to decide if you have any rebuttal?
We do not have any rebuttal.
All right, so then let me summarize where I think we are, then we can go off the record to talk about when we're going to submit the post-hearing submissions. And at the present time, my understanding is that both the city and the appellant have submitted to me all of the proofs, evidence, and witnesses that they want to have me hear in this matter. Is that correct, Ms. Pfeiffer?
Yes, the city has submitted everything, and just so I'm clear, that's exhibit 1 through 14 for the city.
And I was going to come to that in just a moment. So you anticipated me. I have admitted, as we described it conditionally, city exhibits 1 through 14. And then Mr. Cervantes, the same question to you, that the appellant has submitted all of the proofs, evidence, witnesses, and everything else you want me to hear today. And I have admitted your exhibits, appellant exhibits 1 through 30, I believe the count is.
That's correct.
All right. And it's also my understanding that folks have agreed that the city of San Antonio, by the census count, is less than 1.5 million. So I don't apply any part of chapter 143 that applies to those cities with a population of more than 1.5 million. That all notices were properly posted for this proceeding, that the parties have complied with all statutes, civil service regulations, and the collective bargaining agreement, so that the matter is properly before me for a final and binding decision. Is that everybody's understanding?
Yes.
And Ms.
Yes.
Pfeiffer? All right. And then let's see if there's anything else to confirm. Oh, and I received all of the exhibits in the course of the hearing, which means I received during the hearing, meaning the parties offered and I admitted into evidence, often conditionally, city exhibits 1 through 14 and appellant's exhibits 1 through 30. Same understanding that for the city
Yes.
and for the appellant.
I'm sorry I missed that.
That's all right. That with respect to the exhibits, and that city's exhibits 1 through 14 and appellate exhibit 1 through 30, I received all of that, meaning you folks offered and I admitted it conditionally in the course of the hearing.
Correct.
All right. And that's just a fancy way of saying I didn't get anything outside of the hearing. So with that, why don't we go off the record and talk about the administrative matters for submitting the post-hearing submissions.
And does that mean that we no longer live stream on YouTube, or do we still do that?
We would still live stream on YouTube. I just wouldn't have the court reporter capturing the discussion. We'll just come back and summarize it so we don't end up with more pages than we need.
Okay.
So with that, while I'm still thinking about it, with respect to the transcript, I believe, Ms. Schultz, I asked that for the transcript, since we were doing 2 days, that the pages be numbered consecutively. So when we're referring to parts of the transcript, we can do by page numbers and don't have to do volumes. Did I remember that I asked that?
You did.
Okay. And then I think I told you that I wanted a electronic version and a condensed version. And I think I said an E-Tran is preferred, but if you folks only do a PDF, that's okay too. And I don't know, Ms. Pfeiffer, if you've told the court reporter what you want and whether you need to do it on the record or what you want to do.
The city normally does an electronic copy.
Okay. And we'll put all this back on the record when we get there. Mr. Fuentes, what do you want?
I'd like a copy in the PTX file extension format.
All right. I think that's the same thing as E-Tran, but it's good to say the extension. All right. And then back to the court reporter. Normally it's a couple of weeks when you get the transcript ready. Is that a good estimate? 10 business days?
30-day turnaround is normally what we ask for.
Oh, okay. 30 calendar days.
Yes, that'd be fine.
Okay. And then if we, and if you need more time, you can just tell the parties and we can adjust. Things happen, like ice storms and power outages and pipes breaking and the like that we've all had to deal with. And if we get the transcript in 30 days, what's the notion for doing the submissions? And I'm assuming we'll just do one exchange and not a submission and a reply. But let me start with the city. What's your notion? Just one or more?
One is fine, Mr. Hartsfield, and I understand that how we worked it last time worked pretty well, where when we get the transcript from Ms. Schultz, we let everybody know, so then we can count our submission from that time. So however long it takes Ms. Schultz, then we go from there.
Okay. And once you get it from Ms. Schultz, what are you thinking? Are you thinking 30 days, 60 days? What are you thinking?
I was thinking 30 days. Once we get the transcript, I'll send an email. Well, once I receive it, I can send an email saying, hey, the city has it. And then once Ben has it as well, he sends his email. And once we both have it, then we do 30 days from there to the day of submission at midnight that night.
Okay. And Mr. Fuentes, does that generally sound okay to you, with you folks being able to adjust it depending on what happens in your life?
Yes, I think the practice that has worked well between myself and the city is that if either party needs an extension for whatever reason, that we contact you and request consent that it be due at a later date. And I've always worked well with the city and vice versa. But the past practice is 30 days after we receive the transcript and we notify you. I think the only issue that needs to be ironed out, it's really not an issue, but detail, I should say, is whether they're due at the close of business or midnight. So, it's my preference to be due by the close of business, 5 o'clock. So I'd rather not be up working on it up until midnight.
And the city does not have a problem with that end of business day, 5 o'clock deadline.
All right. And I'll summarize all this when we go back on the record. So generally 30 calendar days after you get the transcript, you folks will confirm you've gotten it. And I'm sorry, I said that wrong. Once you folks have gotten the transcript, you'll confirm that, and it's 30 days from when you've gotten the transcript, and it's 30 calendar days. You'll submit your post-hearing submissions by close of business 5 p.m. And then you all will deliver it to each other the next day or by mail or however you want to get it to each other.
That's fine.
Okay. And then I can send my decision to you folks within 30 days of when I get your submissions. and it's all right for me to send it as a signed PDF to council with a copy, I think, to the Civil Service Commission. I think that's what we've been doing. Does that sound right to you, Ms. Pfeiffer?
I believe so.
And Mr. Sventis, does that sound right to you?
Yes.
Okay, and then let's see if there's anything else on my checklist to talk about administratively. There is something that, and this is to help me, because I'm going to do it once I've gotten everything. But to the extent you folks want to submit to me a matrix of all of the other discipline, meaning you tell me it's this state, it was these violations charged, and this is what happened in the settlement agreement, 30 days, 60 days, 75 days. I'm going to end up doing that myself, but to reduce the possibility that I make a mistake in doing that, it'd be helpful if you folks submit whatever you want to submit on that topic. Since you know I'm going to do it, you may want to give me a map of how to do that. And you don't necessarily have to do them all individually. For example, Ms. Pfeiffer, I think in your examination, the chief, you went through and you classed them of these were all before December 2014. If you just want to tell me that, that's fine way to summarize it from your perspective.
And do you want that as, would you prefer that as part of the post-hearing submission or as like a separate document so you can?
If you'll just submit at the same time as the post-hearing submission, you can include it in the body of the submission, or you can put it as attachment A, or however you want to handle it.
Okay.
Whatever makes sense for you folks. And my preference is for you folks to give me a word processing document. You can send a PDF for control purposes, but it's easier for me to cut and paste anything I want to cut and paste from your submissions if you send it as a word processing document. And then the same thing, Mr. Sventis, you can do a matrix however you want to do it. If you want to do it to follow along your exhibit numbers and work it out of the dates and 75 days versus 30 days versus 60 days, et cetera, you can. Whatever works for you works for me.
A question, do you have a preferred word processor, Word or WordPerfect?
I use both.
Okay.
I'm more proficient these days in Word, but I started out with WordPerfect and I have kept it because a number of folks still use that, and it's probably for legal purposes a better word processing system. So I understand why folks stick with it.
Here, here.
It sounds like you're always going to stay with WordPerfect, Mr. Cervantes.
Well, one thing that I like about WordPerfect, it lets you do what you want, doesn't impose its dictatorial formatting on you.
I understand that perspective. And in fact, I got a little piece of software that in theory would let me go in and actually see the codes that you used to be able to see in WordPerfect. And I say in theory because it doesn't work with Word 2019, unfortunately. So with that, unless there's something else to talk about, let's go back on the record and go through what we've talked about, and I'll summarize it and you folks can correct me as we go along. So if we're ready, and Ms. Schultz, we're back on the record. We had an off-the-record discussion about the arrangements for the post-hearing submissions. The court reporter anticipates that the transcript will be available in 30 calendar days. Naturally, if anything occurs that delays that, she'll simply let us know because natural events come along like ice storms that may interfere with it. The parties will confer to confirm they've received the transcript and they plan on submitting their post-hearing submissions 30 days after they receive the transcript. They'll send those to me electronically. I have asked for them to include a word processing version of their submission, either Word or Word Perfect. Those will be due at the close of business or 5 p.m. Central Time. The parties have agreed to allow me to submit my decision via email as a PDF directed to the advocates with a copy to the Civil Service Commission. I advise the parties that I will be creating a matrix about the information concerning other discipline that's been submitted in the hearing, and invited them to submit their own matrix detailing how they think the other disciplines should be viewed based on the dates, the events that occurred for that discipline, and what was the outcome of any settlement agreement that was reached with respect to that discipline. And that matrix can either be part of the submission in the body, or an attachment to it as an Exhibit A or an Attachment 1, whatever works for those folks. And again, if the parties need any additional time, they can confer and request it. Just let me know so I can adjust any notes on my calendar as to when to expect things. And then I think the city's is ready to tell the court reporter what the city wants in the way of a transcript.
I'm sorry, sir. What was that?
Well, the transcript that the city wants is what
Electronic
form?
version.
Okay. And then Mr. Ventus, the appellant wants from the court reporter, what kind of transcript?
The one with the PTX.
All right. And I think I now have summarized what we talked about while we were off the record from the transcript. Anything else that you can think of, Ms. Pfeiffer, that we need to address?
No, sir. I believe everybody has the exhibit, so we're good on my end.
All right. Mr. Cervantes, anything else that you can think of that we need to address?
No,
And Ms. Schultz, I'll give you the chance for the last word. Anything that you're aware of that we talked about and didn't get on the record for you?
Oh, that's it.
All right. Thanks for everyone's time. We stand adjourned. I appreciate everyone's time and cooperation because it makes my life so much easier when everybody's able to agree on the exhibits and make things move as smoothly as they did in this hearing. So thanks for that. Enjoy the rest of your week.
Thank you, sir.
Sure.